Okay. Taip, laba diena visi.
Welcome everyone. We are ready to start our public forum today entitled Reasonable Accommodation, Safeguarding the Rights Starts with Dialogue. And it's my pleasure to give the floor to the Excellency President of the Republic of Lithuania, Mr. Gitanas Nausėda. Dear all, I'm happy to be here with you to deliver a welcome just word for all of you at this forum, which is entitled Reasonable Accommodation, Implementing Rights and Begins with Dialogue. It's my simple observation I want to start with. We all need, we living in Lithuania, we need more understanding, better skills of listening to each other. And we have to do our best in order to establish and to improve the condition of the welfare state in Lithuania. So life is good to everyone. And I'm talking about all spheres of life. And everything starts, meaning talking about welfare state, started with dialogue, even, I would say, disputes. So today, we just we who have gathered at this public forum, we can not only talk about people with disabilities. I think we have to include all persons. As of today, almost 8% of Lithuanian citizens, of Lithuanian residents, have a certain disability. And it's not unjustifiable that many of them still live in exclusion. Just the same, it makes me happy that during the last 5 years, 5.5 years already, we have made significant accomplishments. And the amendments to the law on education, about inclusive education, also the amendments to the unemployment insurance, just which I have been calling for, is also important, meaning in case of redundancy or what, you're insured. Also, the law on the fundamentals of protecting the rights of persons with disability. This is a major also step forward. Also the equality of the rights of athletes, including able and the so-called disabled, athletes. This is, I think, a major improvement. And all this means that more and more persons with disability are included into all our walks of life. Also, the transposition of the EU directive on the transferability or portability of various services into national law is also a major achievement. I do hope that leadership and a good example means a lot, and we have to promote still awareness of the society at large. To the extent possible, we, meaning the President's office, we're trying our best to make this office as friendly, as accessible to all Lithuanians as possible, because just the same, sometimes it makes us sad. Let's remember our idea to make life of those with visual impairments better. Actually, we got some not quite good reaction, because we wanted to put some markings, markings on the steps of the staircase, and part of the audience somehow reacted negatively. But today, it's a pleasure to announce that we pursue close cooperation with the Lithuanian Disability Forum, and in order to improve the situation, and in order to improve the situation in the sphere of reasonable accommodation. It doesn't matter whether we're talking about voting during elections, or some services in various shops, or let's say accessibility to the social workers, etc. So there are fewer or maybe no obstacles encountered by persons with disabilities. Goes without saying that changes sometimes are costly, but sometimes they don't really cost anything. Respect is needed and listening to each other. When we talk about denial of reasonable accommodation, this is discrimination of human rights, and we have to spread this message to our society, meaning so that a person with disability does not have to beg for certain assistance, for support, because a person with disability has a right to be on equal footing. So we have to make sure that all our laws, legal regulation, it's not something written on paper. We have to safeguard these rights, and this has to become, meaning reasonable accommodation, an integral part of our life, maybe in the next year, and the next year is around the corner. So wishing you the very best. Just Merry Christmas, etc. And I'm looking forward to seeing you either in the near future, either here in the President's office or some other places. Thank you, Your Excellency. And now it's about time that we made a family photo with all the participants of the public forum. Scary.
Dėkoju labai.
Thank you, Your Excellency, for very important insights and for your efforts of the President's office, giving us the example, show the examples, what has to be done in implementing equal rights. And right now the floor is given to Indrė Širvinskaitė, President of the Lithuanian Disability Forum. Welcome, everyone, Your Excellency, who's about to leave, all the participants, and also representatives of the Lithuanian various institutions, representatives of NGOs. I'm so happy to see all of you today. And actually, it was the Commission for the Monitoring of the Rights of Persons with Disabilities, which launched the initiative to hold this forum. And we thought it's very important to talk about the implementation, transposition, and implementation of the convention, and about the gaps in legal regulation. Yeah, so this forum is dedicated to the topic of reasonable accommodation. It's very important because it's related to recommendations of the United Nations People with a Disability Committee. And it might seem that this topic is abstract or legal, and it's related to the implementation of or enforcement of legal regulations. And I think the awareness should be promoted of the society about reasonable accommodation. And this is a very important principle of the Convention of the United Nations, reasonable accommodation. So I do hope that today will clarify how this principle is enforced or is implemented in everyday life, in all spheres of life, so that people with disability could work, learn, will enjoy a good quality of life. And I do thank the President and the President's office for hosting this event, because I think the President's office is the very example which shows the example of how the rights of people with disabilities are being implemented. And starting with your first days being the President, I think we saw the example that you really walk the talk, because you actually tried to understand where the obstacles are, let's say, why to make your President's office accessible to people with disability. And it's a perfect example. You show by leadership, and and also it's upon the initiative of the President that the amendment towards the law on equal rights of people with disabilities has been submitted, and we feel this sincere respect to people with disability, and also the concern that not everything has still be accomplished. So once again, I wish you all the best to all of you, and let's talk about a reasonable accommodation, how to improve the situation in Lithuania. Thank you very much. Thank you, Indra Širvinskaitė. And now the floor will be given to Klementina Gruzdienė, representing the Commission for the Monitoring of the Rights of Persons with Disabilities. Hello, everyone, and it's a pleasure, and also, well, it's to talk to you today, and not just to welcome you, not to give it this introductory speech, but as Indra said, well, it's a historic, I would say, moment when the draft, amendment has been submitted to the law on the equal rights of persons with disabilities, and or equal treatment of the person with disabilities. So we still see that there are certain gaps, that equal treatment is not yet ensured in all walks of life, and therefore we have to start this dialogue, and meaning the support to people with disabilities cannot be limited to just paying out the benefits, etc. No, it's much more than that, meaning we have to talk about equal footing, about all the rights that people with disabilities are entitled to enjoy. And thank you very much for coming here. And we'll be talking about a horizontal, basis for the accomplishment. And we'll be talking about reasonable accommodation and the recommendations and the comments made by the United Nations Committee of People with Disability, which were voiced in 2016, meaning this is probably the basis on which from which we have to talk. We have to react to these comments. And we have, of course, as has been said, to promote the awareness of the society, to implement all the reforms necessary. Of course, we might encounter certain resistance, certain confusion on our way, but it's good, because such feelings show that there are changes in our mindset, and meaning we have to change this mindset. I am a mother raising a child with special needs, and my child will have these needs throughout his life. So I have to tell you that if we actually don't ensure reasonable accommodation, then these persons really, they have a conflict-based relation with the environment. So when we talk about reasonable accommodation, so it's not only it's also strengthening Lithuania. It's also working on this sustainable approach to all walk of life. So thank you very much for those who contributed towards organizing this forum. Thank you for attending this forum. Thank you for being concerned with denials, which we still feel reasonable accommodation. And thanks, Indra, as well, for your support. Thank you, Klementina Gruzdienė. As we know, there is a change of our government today, because up to lunch we have still the old government in power, which will change after lunch. And today we have here Liutauras Vičkačka, representative of the Speaker of the Parliament of Lithuania. You're welcome. Hello, dear participants of forum. I can see many colleagues. On behalf of the Speaker of the Parliament of Lithuania, I would like to thank you for this opportunity to be invited for a welcome word. And also my great thanks go to the organizers of this public forum for your effort, for for being so committed towards actual and relevant topics such as reasonable accommodation. Yes, the situation changing, but still in Lithuania, but still we see that social dialogue is not yet at its best. And it's very often the NGOs or the president who have to sort of launch the initiative. And we need not only to think about ourselves, but we have to talk about the universal just principle, but it's difficult. The United Nations Committee of the Rights of Persons with Disability also, we know about it. It keeps talking about the reasonable accommodations necessity, and sometimes we still see that it's being denied. We talk based on experience, on our experience, witnessed by NGOs or by persons with disability, of their family members, and I was, up till yesterday, I was heading one NGO in Lithuania, and I know what it means, how difficult it is sometimes to be treated with respect, with dignity. I'm talking about people with disability. Let's say if you want a taxi to take you to the doctor's appointment, there are still many obstacles to be faced. So, to conclude, once again, my heartfelt thanks go to all of you. And as the president said, well, let's include a reasonable accommodation into all the agenda, into all walks of life that we have to face. Thank you, Liutauras Vičkaška, and it's Professor Jonas Ruškus who will conclude the first part. I don't have to introduce, I think, Professor, a former just member of the United Nations Committee of Persons with Disability. Well, when I traveled around the other countries, and I used to think, we can hardly expect this situation, something I saw elsewhere in Lithuania, because I saw many progressive countries. And I'm talking here about reasonable accommodation, because denial of reasonable accommodation is regarded as discrimination. And having actually approved of this provision in Lithuania, that denial of reasonable accommodation is discrimination, will make a significant leap and step forward. And you probably, know that I'm talking now, it's a part of Article 5 of the Convention, equality and non-discrimination. So this is the basis, actually, which allows to ensure non-discrimination and equality. The Convention of the United Nations goes into further details where reasonable accommodation is particularly important, and it also comes up with various standards of I'm talking about Article 24, education, 14, and reasonable accommodation prisons, also 27, reasonable accommodation in employment and the workplace, and 25, healthcare. So I'm talking about horizontal and vertical provisions embedded in the convention. And as a former member of the UN Committee of the Rights of Persons with Disabilities, I understood how important it is. Not to recap what has been said, I want to say the following. What do I mean by reasonable accommodation? We had the discussion the same as, let's say, how to ensure reasonable accommodation in educational establishments. And I heard some, members of the government voice an opinion that it could be a disproportionate and burden. And the convention also talks about it. Is it really disproportionate or a new burden? Because the convention said that necessary and appropriate modification adjustments have to be ensured, but they don't have to impose a disproportionate and undue burden. We need it in a particular case. And that's important to ensure to persons with disabilities the enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms. So we have to further discuss it. The convention does not say anything that even in the case of disproportionate or undue burden, that meaning we have to then we have to ensure reasonable accommodation to the extent possible. I also was chair of the working group regarding Article 6 of the Convention, and it says that accessibility and reasonable accommodations are are parallel. What I mean by accessibility entails the identification and elimination of obstacles and barriers to facilitating access on an equal basis with others to the physical environment, to transportation, to information, communication. But we do understand that it's difficult to do that. So there comes a moment when we talk about some individual sort of adjustment or modification, and then individualized approach based on a dialogue. Let's say if a child is enrolled into mainstream school, so the administration, teachers, and parents, they start a dialogue and they look for possible solutions, and then we talk about reasonable accommodation, individualized approach. So I do hope that this amendment to the law will be enforced. The sooner the better. Thank you.
Su Jono Ruškaus žodžiu šiandien.
Many thanks. Jonas Ruškus finished the welcoming part. Now we'll move to the presentations. I'd like to inform you what's ahead of you and to discuss the House rules. I'm Simona from the Lithuanian Disability Forum. In case you have any questions or proposals, come up to me and let's talk. Now, we'll have two sessions of presentations. The first will focus on the international context. Two speakers will speak in English. If anybody needs interpretation, take the headsets. The first speaker will speak in Lithuanian, but the second will deliver in English. The first session on international context will be followed by a lunch break. And later I will speak about the Lithuanian context, namely the implementation of reasonable accommodations, gaps in legislation, and so on. And the third part will be discussions. We'll try to discuss the first steps and the mechanism to help discuss the mechanism in each field. It must be discussed in each sphere. Matters appropriate for education will not be suitable in employment, for example. You'll have an opportunity to ask questions after each presentation. There'll be a question and answer sessions, and you'll have to raise your hand in order to ask. So these are the rules. Now the first presentation will be delivered by Egidijus Grigonis. He's a member of the Council of the Lithuanian Disability Forum, as well as represents the Lithuanian Paraplegic Society. He'll tell us about the principle of reasonable accommodation in law and practice. The floor is yours, Egidijus. Now I'd like to ask you to show my slides. I've been introduced, so nothing else is necessary to present myself. This slide shows the definition of reasonable accommodations as stated in the Convention. As a legal instrument, reasonable accommodations have started to be applied in the United States. And it was not in the field of disability, but religion. In fact, reasonable accommodations is an institute or a concept of law. As mentioned by the professor, it is horizontal. It embraces a large number of convention provisions in different spheres of people with disabilities. In 2013, a team of researchers at the European Commission tried to overview how such concept stemmed out of law. As already mentioned, the United States and Canada started applying reasonable accommodations in order to ensure the rights to religion. The European Union took a different road. It chose the path of accessibility in employment relations. I enjoyed certain insights in the research. One metaphor explaining the difference between reasonable accommodations and accessibility. And it says, reasonable accommodations are tailor-made like a tailor-made suit. Looking back at history, when the United States started emphasizing disability is the case of 1979. It is the precedent influencing and impacting the rights of human rights. The background of these proceedings: a student of the college with hearing disability could read the content from her lips, but she was denied a certain program. She was unable to study at the college. The college decided reading from lips does not ensure security in surgery rooms, for example. And in such circumstances, when employers wear face masks. So the Supreme Court rejected her claims. It ruled that reasonable accommodations cannot be used as an argument for the modification of study programs. And this case shows the genesis of these rights before the convention. We can also speak about the Swiss case. In this case, the ECHR, in addition to the European Convention on Human Rights, applied the provisions of CPA-D. The person who had a minor disability was unable to undergo military service and had to pay taxes. He appealed to the court claiming he had no possibilities, no accommodations for this service. These proceedings are of the year 2012, and it is one of the pilot or starting cases when the courts starting focusing on reasonable accommodations. Switzerland had not ratified the convention at this time. However, the ECHR considered it unimportant and applied the provisions. Lithuania ratified the convention on the 27th of May 2020. And now let's have a look at the provisions of our constitution. It says the provisions of international treaties form an integral part of the legal system of Lithuania. This particular Article 5 of the Convention has been already quoted. It says the state parties shall take all appropriate steps to ensure reasonable accommodations. This slide shows an interpretation by the UN Committee. It interpreted that reasonable accommodation is an intrinsic part of the duty of non-discrimination. It also implies making existing facilities and information accessible to individuals with disability. It entails also modifications of equipment, reorganizing activities, and so on. As noted in my example from the US courts, the court ruled studying curricula, it was not mandatory to modify and accommodate curriculums. In fact, reasonable accommodation duties are different from accessibility duties. Both obligations aim to guarantee accessibility. However, the first is proactive ex ante, and the second is ex nunc, in response to the request from a person. You did mention reasonable accommodations at the office of the president. Now it is accessible by wheelchairs. However, not all persons with movement disability can easily use the ramp. And reasonable accommodations will stand out, will be used only after an individual request. This slide gives a broader description of this ex nunc duty. Reasonable accommodation must be provided at the moment the person requires access or some other accommodations. The focus is on a dialogue. The entity to which the person with disabilities appeals does not always know how accommodations are possible. The UN committee makes a distinction between those obligations. The first is objective, necessitating necessary amendments, and the secondary obligation obligates not to create undue burden. It is emphasized that denial of reasonable accommodations is possible only on objective criteria and proper investigation, examination of the situation. Article 9 speaks about accessibility. Accessibility is viewed as a precondition. And secondly, reasonable accommodations should be accessible to disabled persons on equal grounds with others. This obligation is unconditional. However, they are not individualized. The obligation must be applied immediately, and limitations on the grounds of proportionality are possible. In terms of unconditionality, still they imply some restrictions, be it finance, time, cultural heritage. And now discussions take place to what extent reasonable accommodations can justify changes. The committee says in some cases changes are possible. However, unconditionality is a must at the same time. This slide emphasizes that accessibility is implemented gradually until reasonable accommodations are realized. This provision says that in some cases reasonable accommodations can undergo changes. And the question is how the change is implemented. Now I'll move to the cases of the European Court of Human Rights dealing with reasonable accommodations. In the case Cam, the girl was willing to study in a musical academy, but she was refused because of visual impairment. The academy argued it had no opportunities to make accommodations, and the court ruled that discrimination on the grounds of disability includes the denial of reasonable accommodation. In this particular case, the ECHR took a very brave step. It started applying the provisions of CPRD. One more important case. And VIEŠASIS versus Turkey from 2018. The background is described in the slide. Namely, a first-year student suffered a spinal injury and was confined to a wheelchair. He requested accommodations in the facilities. His studies were to start in 6 months. The faculty refused because of old premises and explained it was not mandatory according to law. The ECHR hears cases on the grounds of breaches of the Human Rights Convention. However, it places emphasis on the CPRD as well. The court did not support the applicant's arguments that the facilities had to be accommodated immediately. At the same time, it ruled the faculty breached the applicant's rights to reasonable accommodations. And it's not the judgment itself which is so important. It is the dissenting opinion by Judge Lemens. The court ruled no breach of the European Human Rights Convention. However, the judge stressed the student requested accessibility, but the court spoke about reasonable accommodations. The ECHR failed to make a distinction between those two concepts. And the judge spoke about temporary accessibility, reasonable accommodations. He placed a great deal of the obligation on the student. The student did not cooperate sufficiently after he had made his request. Failure to cooperate led to the fact that the measures offered could be discarded because of a breach of dignity. However, the student did not propose any solutions to ensure his right to study. And the faculty had been ignorant of his needs. There was no finite list of what reasonable accommodations meant, and the student was able to be initiative. Judge Lehman emphasized the duty of accessibility could be implemented gradually, considering the state's capacity and time limits. As mentioned, the student had not informed the faculty administration why the accommodations or measures offered were not suitable, and dialogue was missing. The absence of dialogue the parties had not considered moving lecture rooms to different stores or to different facilities. Now let's speak about Lithuanian proceedings. The equal opportunities ombudsperson found a violation in one case, and the court confirmed the same finding. The Lithuanian Administrative Court relied on similar arguments like the ECHR. The court did not use the specific concepts, but it said the dialogue was necessary. It inquired whether some other solutions had been made. We can see from this case that the Supreme Administrative Court was not familiar with the convention itself. Its proposals to assess accommodations were quite strange. The court spoke about social taxes, or about the possibility of accompanying a disabled person in the polyclinics. It did not explore and other options based on the level of the person's disability and other options available. The sphere of labor relations, employment relations. The law of the European Union has another concept which is established in a directive. The ECHR has ruled that the concept of reasonable accommodations should be interpreted as the removal of different barriers preventing persons with disabilities to participate in professional lives. And it is a duty of the employer to make measures to adapt the workplace. And measures should be implemented effectively. What examples are possible? Facilities and premises should be adapted and accommodated. Working time models should be introduced, tasks should be shared, training should be organized. Different accommodations are necessary for different forms of disability. And the court also spoke about a reservation. Such accommodations should not place undue burden. This list of accommodations is only an example, and it can include account should be taken of financial and related costs, the size of the company, financial resources, availability of public funding. And my last slide shows the states which have ratified the convention, including its protocol. So that's it from my side. Well, I did use the legal language, but I hope my presentation was clear.
Be galo įdomu ir turbūt labai vertinga tokia apžvalga.
Thank you very much for Ms. Grigonis. At least I found it very challenging. I hope you thought the same. Now we have a couple of minutes for Q&A session. If you have a question, please raise a hand and I will come up with a mic. In the absence of questions, then we are going to continue our agenda. It's extremely just nice to me to present to you Jamie Bowling, with whom I have a long-standing friendship, and also the she from Sweden, and the lawyer Mari Silsalo, and both are going to talk about reasonable accommodation in Sweden and the situation in Sweden.
Some practicalities. Good enough. Hello, everybody. It's an honor to be here today, and we'd like to thank the Lithuanian Disability Forum for having the cooperation with us on this comparison, a reasonable accommodation between Sweden, Latvia, Lithuania. I am Jamie Bowling, and with me is Mari.
Yeah, hello. My name is Mari Silsalo. I work as a legal advisor in Independent Living Institute together with Jamie.
Okay, next slide. And this is just what we have on the agenda. We'll talk about the Independent Living Institute, who we are, the cooperation we have here with Lithuanian, a bit of the background to our discrimination legislation, and then more detail from Mari on the act itself, where we are with our act, the impacted achievements in Sweden, and lessons learned. Next slide. So independent living, it's a philosophy, but also a world movement. I'm sorry, my voice all of a sudden is strange. I think it's better. And we work then to promote independent living within Sweden, but also within Europe, through the European Network on Independent Living, where I'm also the co-president. And what does it mean? What's independent living? It means disabled people being able to have equality in life. So we're talking about a key tool that will make this possible in this country and that we have in our country. It means full participation, self-determination, that we have a rights-based approach. We don't care why people have disabilities and compare diagnosis. We care about being able to have a rights at an individual base. Self-respect and empowerment, just being ordinary people, being able to take the bus in front of my house, which I can't do in Sweden. Next slide. So in the Independent Living Institute, what is it? It's just a small foundation in Stockholm, founded in 1993 by a man called Otto Fratska. Some people in the movement would have heard his name, but he's quite famous for having brought independent living to Sweden, and also the concept of personal assistance to Europe, I would say, where we have a personal assistance legislation in Sweden since 1994. The foundation is project funded, so we work on projects like this one, and we also work on projects on the CRPD or on using the law as a tool, migrants with disability, and many other things. We have an international board, about 10 employees, and we're a member of the European Network on Independent Living that has members in about 42 countries. We're thankful for this cooperation we have here. We've done different things passing the time. We usually meet some of our colleagues at the Freedom Drive every other year in Brussels, where we meet the members of parliament, and we also take to the streets and scream about our rights. We think it's fun, and it's also good to meet each other, to compare how is it in each of our countries. We've had a training on migrants with disabilities, I think it was last year sometime. We talk about personal assistance and other things. So the background, Sweden started 2003 to 2012. We had the movement quite strong, where we took to the streets once a year, and we called it the Accessibility March. When it was at its highest, we had about 600 people in Stockholm on the streets. We had demonstrations in about 20 different places in the country. We wanted inaccessibility to be considered as discrimination, which it finally became. This is about a little bit before the CRPD was signed. It was also about the time when the EU directive was being talked about, which unfortunately found its way into a drawer, but I heard that it might be being taken out again, so we'll see about that. Next slide, and then Mari, you take over.
Yes. Now I'm also going to be speaking a lot of this legal jargon. So you guys are going to just have to stop me if this gets too inaccessible. But I give it a try. First of all, I was eating a very nice dinner yesterday and talking to my colleagues here in Lithuania, and realized that we have a very different approach to international law in our two countries. So before I go into anything, I'm going to have to say that Sweden has a dualist system to apply international law, which means that when a convention or treaty is ratified into our legislation, then it will not automatically become part of the national law. The only thing that we do when we ratify international treaties is that we go into an agreement with the international body that we have obligations under the treaty or convention, and we have to fulfill those obligations. So when we ratified the Convention on the Rights of People with Disabilities, then we went into agreement with the United Nations and said, yes, we have obligations under the convention, but they did not become part of law, the national law in Sweden. In order to get things to become part of the national law in Sweden, we have to incorporate them into the legislation. So, if we're talking about the implementation of the reasonable accommodation as a principle, yes, I move around a lot when I speak, so thanks. So if it comes to the implementation of the principle of reasonable accommodation into Swedish law, then what had to happen was that there would be changes in the national legislation which will then reflect the principle of reasonable accommodation. And I'm going to give you a very quick rundown of how this works a little bit in Sweden, because otherwise it's very hard to follow the rest of my presentation. The most relevant piece of legislation here probably is the Discrimination Act 2008. And it states different forms of discrimination, such as direct discrimination, indirect discrimination, harassment, sexual harassment, instructions to discriminate, and there is one more, inadequate accessibility. And that form of discrimination means that it is prohibited as a form of discrimination when a disabled person can't get access to something, it's inaccessible. And this, so that includes an obligation to ensure adequate accessibility. And ensuring adequate accessibility is done by implying what's called reasonable accessibility measures. And those reasonable accessibility measures, they include following general accessibility requirements, and as well as taking some sort of specific measures to make things accessible, or it could also include providing support services for someone to have accessibility. And what makes accessibility measures reasonable? There are different factors that are considered, such as, for example, existing accessibility requirements. For example, this is like the minimum requirement. You have to follow those. But also the financial and practical conditions that are in place for the one who is obliged to provide these reasonable accessibility measures, or like duration of the relationship between the person and the party that has the obligation. And also there could be some other specific circumstances which play a role. So like if this is the test for the reasonable accessibility measures, and when something is not really following or falling into these conditions, then it's considered unreasonable. Therefore, there is no obligation to provide that measure. And an individual can bring a claim of monetary compensation to the court if they have been discriminated against, and with that the court will take up the case, and when they win, they can get monetary compensation. There are like rules for the size of that monetary compensation and these kind of things specified as well. I guess I'm not gonna go over those right now. So if we are then asking the question, I remember when I was reading the program before coming here, and I was going to talk about reasonable accommodation in Sweden, and I almost felt like a fraud, because I would say we are not quite there yet. I'm going to explain that in a minute, why I'm saying that. I would like to introduce a case of Rickard Selin. Rickard Selin is a lawyer in social law, and he has quite a lot of lecturing experience. And the case is about when Rickard Selin applied for a permanent lecturer position in Södertörn University, close to Stockholm. And as he's using sign language interpretation when he gives his lectures, he obviously needed that as well. And he was considered the most merited candidate by the interviewer. And he also came so far in the employment process that he was asked to give like a trial lecture before being employed. But after the trial lecture, the employer contacted him and said that they're going to terminate the employment process because the sign language interpretation would be too expensive to accommodate his employment. So it was going to cost 52,000 Swedish crowns per year, and that was just too much, the employer thought. So Rickard Sjöldin brought a case in these circumstances. And what I'm going to do now, I'm gonna compare Rickard Sjöldin's case with under the Discrimination Act 2008 with Rickard Sjöldin's complaint under the CRPD to the CRPD committee. So, if it comes to what happened when he brought a claim under the Discrimination Act, then the court found there to be no discrimination because the court also assessed that if we go back to these different circumstances in the test of whether something is considered reasonable accessibility measures, then in terms of like the circumstances for the university, it would indeed be too expensive to have to pay that sign language interpretation. So there was no violation of the Discrimination Act 2008 found, and there was no remedy at all provided to him. When it comes to the Rickard Sjöldin's complaint under the CRPD to the committee, then committee did find a violation of the CRPD rights, and the committee pointed out different types of violations actually. First of all, the committee found that Rickard Sjöldin's case shows how the decisions and actions of the state authorities limit the quality of disabled people in general, not just Rickard Sjöldin, everybody actually. And then even before we even come to that assessment of whether 52,000 per year is too much or not, there should have been dialogue, like many speakers before me have here said. Central to reasonable accommodation is dialogue, and we don't have that in Discrimination Act. The Discrimination Act does not really emphasize an obligation to have a dialogue before you even start applying of any measure or not doing that. So there was no dialogue with Rickard Sjöldin either. And then, of course, that if it comes to Rickard Sjöldin as an individual, he was denied reasonable accommodation, which is in violation with the convention. And there was also a de facto discriminatory exclusion of Rickard Sjöldin. So there are like, beyond that, the actions of the state authorities and the university would exclude actually everybody, but also that Rickard Sjöldin personally was affected. Oops, sorry. Now, this is not to say that the Discrimination Act 2008 would not make a difference. Oh yes, it made a difference. We are very, very happy that we have had this legislative change. I'm showing a graph with curved lines, and what this graph shows is the amount of complaints to the Equality Ombudsman divided by the different discrimination grounds. So it starts from year 2015 and ends in the year 2023. And I have noted down 4 discrimination grounds here: disability, ethnicity, gender, and age. One of the most, the highest number of complaints, according to this graph, we have had in disability and ethnicity. And what we can see here, why I'm showing this, is that if you look from 2019 to 2023, there has been quite a significant increase of complaints, especially in disability and ethnicity. And I mean, yeah, before you guys go like, oh God, you just can't stop discriminating against people here in Sweden, right? No, it's not that. There has been statistical research done also on the prevalence of discrimination itself, and it's not increasing like this. What this increase is the impact of having a very explicit prohibition of inadequate accessibility, and then very, very explicit obligation to make accessibility possible. It creates a discourse that is wrong to have the things inaccessible for people and discriminate against people that way. It makes it explicit for both the individual but also for the authorities. And therefore, it empowers people to submit a complaint of the breach of their rights. This sometimes does not lead to actual remedies. I'm going to go over that in a minute here in my next slide. But it does quite often, this monetary compensation for discrimination, it has an effect also to really address and correct the discrimination. And what's also very important here is that when something is explicitly stated in the legislation, then the regular law enforcement and law implementations systems start to apply as well, which means, for example, in Sweden, that means that since we have the inadequate accessibility as a form of discrimination stated in the law, the regular data collection mechanisms that are in place start to apply for this area as well. There is a much more regular data collection. We become much more aware of the discrimination that is happening. The numbers don't go up because we keep on discriminating against people. The numbers go up because it becomes visible. So, and if I am going to my last slide, then it is our lessons learned. Because, I mean, when I go and speak internationally about the Swedish experience, I quite often disappoint people because they think that, oh, now she's coming from this wonderland of social rights, and now she's going to tell us exactly how to do this. And because in Sweden they have it perfect, and they will know how to do this. And apparently I'm not doing that, right? But what I can do is that Sweden is a very old welfare state, obviously, and Sweden has been very early in this type of changes to recognize discrimination, to prohibit it, to recognize social rights, to provide people with different types of services and supports. So we have had time to learn from these processes. We didn't do this perfectly, but we know what went wrong, and we can go and share these lessons learned. Of course, we learn from ourselves as well, and I hope that our lobby for reasonable accommodation will lead to that. One day I will come here and say, yes, we do have reasonable accommodation in Sweden. But we will see, time will show. So in terms of our lessons learned, so the first thing that really has been an issue in practice for us is that the Discrimination Act does not really cover all areas of society. And this is something that the Convention is very, very adamant about, right? We have heard about this before today, that the obligation of reasonable accommodation and even further, the obligation to ensure non-discrimination has to apply everywhere, to everybody, under every circumstances. It's an obligation of immediate effect. So it has to really apply. There is no way of not applying that principle. But the Discrimination Act, while it does include areas like education and healthcare and employment and these things that have been mentioned here today, it does not really apply to everything, such as, for example, some public organizations. And one example of where the Discrimination Act does not really apply is asylum processes. So asylum seekers can't really bring a claim under the Discrimination Act during the asylum process. That's quite a significant area of somebody's life to not have good discrimination protection. And once the law is exacted like this, it's hard to get it to change. You will be stuck with it, so it's better to enact it the right way from the beginning. Then the second one, I have touched upon it actually already before here, but yeah, the inadequate accessibility and the obligation of reasonable accessibility measures is not really the same thing as reasonable accommodation. It's kind of our Swedish version of reasonable accommodation. And it's not quite as good as the principle of reasonable accommodation. So the things that we are missing, like the Rickard Schalin's case showed, things like absence of an explicit obligation to have dialogue, and how the assessment of reasonability or undue burden is made, differences there. They do matter, because Rickard Schaline had to go all the way to Geneva to get his right recognized, and not everybody can go all the way to Geneva to get such basic rights recognized, because people won't have the resources. They might not be lawyers themselves. And then last point I would like to touch upon, as I mentioned briefly here, that an individual can bring a claim of monetary compensation under the Discrimination Act, but that itself does not really correct already occurred discrimination. The Discrimination Act is actually missing an explicit obligation to correct already occurred discrimination. Yes, it does include an obligation to prevent discrimination, but when it already has occurred, the only thing that can happen is that the claimant, the person who has been discriminated against, can get the monetary compensation. That in itself doesn't do anything with the actual discrimination. And that is an issue that we deal a lot in praxis. It happens even that when someone brings a claim of this monetary compensation to the court, we do see it quite often that then the other party will just go and, okay, we agree to pay the compensation before the court proceedings even start as like an out-of-court agreement, so it never even comes to the court. And then we are really missing out on the recognition of discrimination. So, yes, I would like to give some space for some comments and questions from the audience. We have about 10 minutes here, as long as I understand the schedule correct.
Ar turime klausimų? Taip, prašau.
Do we have questions? Hello, Josef Bernatavičius, Lithuanian Paraplegic Association head. My question is, you mentioned that recently there has been a significant increase of complaints, particularly on the grounds of disability. Do you have any statistical data how justified those complaints are? And how many complaints have been sort of satisfied in percentage area?
Yes. I would actually love to have a good answer to that. I don't. What I can do is I can explain you a little bit how this works, a little bit what happens when a complaint comes into the Equality Ombudsman's office, and then I can also give some of the data that touches upon the thing you're wondering about. When a complaint is received by an Equality Ombudsman, it is registered, but not all of the complaints will really be inquired by the Ombudsman. There will be only certain amount of complaints where the Equality Ombudsman will start an inquiry into the circumstances of the complaint. So, if you are asking me, like, how valid are the complaints, we don't really have any coherent statistics on that, because not every complaint is going to be inquired. Only thing I can say is that overwhelming majority of these complaints will not be inquired by the Equality Ombudsman. That might say something about about how well grounded these complaints are, but mostly it says about what kind of workload the Equality Ombudsman has and how we really do have issues with capacity to inquiry into people's complaints. And then if it comes to the other part of your question in terms of like how often there will actually be a remedy as a result of a complaint, then of course when the Equality Ombudsman does choose to inquiry complaint, then they will give they will state the violation. They will say what went wrong. So there will be a recommendation of what should be done, but that recommendation isn't always followed. And then the person can bring that they will have to bring the claim to the court. And it does happen. I don't really have a number for you to give how often it happens because of the things I said before, but it does. People do bring claims into the court. It is every year a few cases, and since there are also luckily there are rules to lighten the burden of legal costs on the claimant side as well. Those rules aren't great, they have issues, but they're there, and that makes it a little easier for a claimant to actually access the court system and ask for their compensation. So that's about what I can say. Hope that answers your question somewhat.
Dar noriu papildyti.
I took a case I sent a complaint to the discrimination ombudsman, so I'm one of those in that statistic because I live up 500 kilometers north of Stockholm. I booked a train ticket to go to Stockholm for work because I work in Stockholm. But when I get to the bus station, I didn't realize that part of it was on the bus. And then the bus wasn't accessible. The guy says, "Can you walk?" No, I can't. So I couldn't take that bus to get to the continued train. What we did is hop in the car and drive really quick, and we actually made the train. I sent it in thinking this bus used to be accessible. Why isn't it accessible anymore? I didn't realize I had changed that. And the letter I got back was saying, yeah, you maybe were discriminated against, but we're not doing anything about this. And so I could have maybe gone to the court, but I don't have the time, the patience, or the money to do that, so I dropped it. So there's a lot of cases like that. Some of the cases they take to the courts are the cases they think might make a difference and change the future. So they'll, how do you say, be selective in that way.
Truputį galima patikslinti truputį informacijos.
Could I just specify some information? As I understand, if the ombudsman takes some decision, then does the sort of case go to court, or maybe there could be some mediation process started on the basis of recommendations to settle the dispute?
Yes. No, the case does not automatically go to the court, even when the disability ombudsman decides to look into it, inquire it. That could be a next step in the process. That in that case, what happens when the equality ombudsman inquiries into a case is just they will look into it, analyze it, and they will state whether they found violation under the Discrimination Act or not. And yeah, that will include a recommendation of what to do in case there was a violation. And they can choose, as Jamie said, to even go further and support or legally represent the claimant while bringing the case to the court as well. And then there will be, then it will be brought to the first stage of the civil court in Sweden. And then the process will be like when the person wins in the court and gets their monetary compensation, or it could also be they lose, and then it goes to the regional step of the court and to the so forth and so forth. So that's how it works. And then if it comes to alternative kinds of like mediation or compensation procedures, there aren't necessarily very many alternatives. It is mostly this kind of outside court agreements to pay the compensation anyway, even when there has been no court decision. It also can be specifically in the area of employment. There can be discussions like when the trade union gets involved to actually correct the discrimination or compensate the person for it. But those are not, they are quite limited. Would you like to say something as well?
Ačiū labai. Ar dar yra papildomų komentarų?
Thank you very much. Any additional questions to ask or comments to be made?
Jamie, I just wanted to ask you about the bus. Is it accessible now or is it still inaccessible?
I live in the country, so the bus that goes in front of my house, it was more accessible in 2005 when I moved there, because it had some sort of an elevator or a lift. But then they took that, they got a new company and they took that out. So now it just has Wi-Fi, but no way of getting into it. And that was since 2005, so it's inaccessible. But this other bus was the one going from, once I get into the city, that city to the next city, which is even a bigger line. It's not the line out into the country. That used to be accessible, and it is not any longer. So it's just getting worse, unfortunately. And that's because there's exceptions to the legislations. They make an exception somehow. I used to know, I've given up on this whole issue, but they had the exception that, yeah, I'm not sure exactly, but there was an exception why they don't have to make that bus accessible.
Yeah, remember we have this part of the reasonable accessibility measures concept is also accessibility requirements. And those have their own, completely their own way of working. We won't have time to go through that, but that's where the exception is.
Ačiū labai, Jamie ir Marija.
Thank you, Jamie. Thank you, Mary. It is very helpful and useful to listen to the experience of other country. Now we are having a coffee break until 10 minutes to 12. And thanks for our audience, for those who are listening to us remotely. Please come back at 10 minutes to midday.
Ačiū labai visiems sugrįžusiems, atsiprašom, kad
Thanks to those who came back. We are sorry our coffee break is taking so much of your time. I hope you are enjoying it. Now we should continue our session, and now we'll move to Latvia. The situation in Latvia will be presented by Gunta Anča. She's our friend and partner. She represents the Latvian umbrella body for disability organizations, Sustento.
Hello, everyone. And it's really nice to be again in Vilnius, in Lithuania. I've been here by other reasons, but I don't have possibility to be together with our friends and colleagues from Lithuanian Forum for People with Disabilities for quite a long time. So it's always nice to come back again and talk about different things. Today I'm going to talk to you a bit more about the situation in Latvia and about situation in Latvia and reasonable accommodation, of course. Just few words about our organization. Exactly like Lietuva's organization of people with disability forum, we also are an umbrella organization, and we have 55 different organizations, and we are doing a lot of job according advocacy, try to change the attitude toward disability, and a lot of other things. It's not gonna be what I say you today. Today I'm talking more about reasonable accommodation. And when we are talking about reasonable accommodation, it's quite strange situation, to be honest. Nobody in Latvia uses terminology reasonable accommodation. We are doing something, and I'll show you more what we are doing in that field. But we are not named it, which is quite strange, I would say. But still, it works, and as you can see in my slide, normally the idea comes from European Union. I don't know how it's in Lithuania, but in Latvia quite a lot of good things are coming from European Union just because they have some kind of umbrella over us. So I'm going to start by work. Why I'm going to start by work? Because it is a field, I would say, where you can find much more examples of reasonable accommodation like in any other field. As I said before, it's not included in our legislation like a reasonable accommodation, but you can find it in different services provided by a national agency of employment in Latvia. So I try to explain you some of the ideas what we are using in Latvia from one hand, and I try to divide it from accessibility, because as you said already, accessibility, it's not reasonable accommodation. So let's start. A bit about statistic. I don't know again a situation in your country, but in our country, the people with disabilities who are in a working age is quite a small number. It's quite a small number. Why? Because elderly people also have the possibility to get disabilities. So it means the number grows, and the number grows because many older people getting disabilities, but of course they are not interested in the work or in the employments. So only 36% are working age for people with disabilities in my country. Then we divided it to the groups, you know. You said you have a percentage. We have groups of disabilities still like it was before, but behind those groups we also have percentage. So the first one is loss of possibility to work from 70 to 100%. The second is from 50 to 75, I think. And the third one is from 20 to 50. So you can see that the biggest number of people has this third group, or let's say not very severe disabilities. And now one more slide which will show a bit more situation. According to the groups, you could see how many persons are employed. And you can see that, of course, the worst situation is with a more severe group, the first one. A bit better is with the second one, and much more better, but not good, I would say, is with the third one, group of disabilities in Latvia. And so what can we provide? What can we provide as a reasonable accommodation? I mean, as an individual support to persons. The first one is subsidized working places. Subsidized working places, it means that person can get a job which is paid by government as subsidies, and it could be for 2 years. It's terminated. After 2 years' time, the person should start work without subsidies. If you like my opinion about it, it's a bad experience. It's bad experience because mostly people with disabilities still need support, and mostly business partners are not happy to have them without any kind of support after that. So we have some kind of support for the employment. When person is employed in a supported workplace, you can see you can get support from ergotherapist. So it means the person will come, the specialist professional will come to your office and help to arrange everything around the workplace. You can get a support from different other specialists, and it works like that. And one more possibility is to get a supported work in non-governmental organizations. It's a very, very popular, especially in the organizations of persons with disabilities. From one side, we have a feeling that it is support organizations, because you can get stuff, paid stuff, at least for 2 years for free, or just paying taxes. And it's also very important for people with disabilities, because they can gain some kind of, I would say, understanding. What does it mean work? What does it mean wake up in the morning and go to your work every day? Not only when I like to go there. And it also gains some skills for those people. It supports measures according subsidized working places. Now we could continue with my next slide. And we have also some kind of special motivations programs. Those programs also is in general, but there are a lot of individual, or I would say reasonable accommodations according what people need. For example, it's sign language interpretation, if people need that. There is also individual consultations made by psychologists. There is also different kind of trainings and so on. So I can't say it's exactly reasonable accommodation, but still it's some kind of reasonable accommodation. And of course it's quite difficult to get this border or line between accessibility and reasonable accommodation. Those motivation programs are very popular, and people can get more and more jobs, people with disabilities, during those programs. And yeah, and services, support services are provided and so on. Yeah, and the next one is support to the inclusion in employment. Also, if you are an employer and if you would like to get a person to work with you, there is special support to you and special support to people with disabilities. So an employer can get a special training how to employ a person with disabilities, and after that this employer should, I would say, I hope so, should understand exactly what kind of reasonable accommodation that person need to work in that working place. Is it work well always? I'm not so sure about it, but still it works, and many employers employ persons with disabilities when understand better the situation. There is special services provided to make workplace more accessible or to provide reasonable accommodation for concrete individual person with disabilities. It is about everything. It's about table, it's about computer, it's about different kind of technical aids, and our budget from the National Agency of Employment paid for technical aids, which are important to work in that concrete working place what person would like to do. So it's also about sign language interpretation, and it's also about support to the person who tried to get a job or to person which is working. It's a special kind of support person which could be paid also by government to do the job. Yeah, it's a very shortly, and I understand it's not exactly reasonable accommodation, but we don't have any more. So whatever we can find, we try to explain to you, but we still hope that maybe even this conference will be something which push us to go and say, you see, Lithuania is doing that, and it always works very well. So we are going now to education. And education, we also don't have exactly anything said by reasonable accommodation, but still I put some kind of framework or some legislation acts which say something about it. So in general, if the child with disabilities come to school, the school which is in the nearby the place where the child is living, school should provide accessibility. Should provide accessibility, I mean to put ramp, to put elevator, to put whatever. I also am not sure that every school does that. Quite often the answer is that it's too expensive. You can see we have 2 or even 3 floors. You see we can't put elevators and so on and so on. But still, in general, it should work. We also have special educational programs or special educational programs to children with intellectual disabilities, to children with autism, to children with different other disabilities, even to those who need special rehabilitation. And school should provide these special individual programs to those children. Sometimes it's okay, but sometimes it's also not so much okay. Those programs are, we still in Latvia still have also special schools too. And we also have rules to provide educational development plans in each school to provide the best development options for children with disabilities and to reach the best result what the child could reach. It's also very individual, and it's also provides some reasonable accommodations in cases when child need different kind of technical aids, for example, for accessibility. We also talk more about using a different kind of technologies, so of providing accessible learning environment. We still have a lot of discussions about deaf children, because Organization of Deaf in Latvia said that they can be happy only to be in a special school. So we have 2 special schools in Latvia for deaf children, but children with other disabilities try to go to normal schools and try to be involved with different results, I would say too, but still we try to do it very much, and yeah. And now a bit more about process. So as I said already, it's individual education plan. We are also talking about assistance for children. So children go to school together with assistants, which provide very practical support, and also teachers in those classes where are children with disabilities have assistants as teacher assistant to provide support as a reasonable accommodation to child by reading or doing whatever the child should do in that situation. Yeah, you don't have any possibility to see what time it's now, so I can go further, and yeah. So, and I think the last one is about healthcare. I'm sorry to say, in healthcare we don't have anything even written, anything which is much more or less like reasonable accommodation. So we can go to the next slide. And normally the situation is that everything should be accessible. Healthcare, according to the accessibility, is one of the most regulated area in Latvia. So healthcare institutions should be accessible, or even must be accessible. Doctors can't open their cabinets if they are not accessible. You can't have pharmacy if it's not accessible. And when you come to Latvia, you can see that all our pharmacies are accessible. There are lifts, there are ramps, there are everything, but they are accessible. So from one side, accessibility is provided, but from other side, understanding about reasonable accommodations depends on individual attitude, I would say, and that is bad. If the individual attitude is good, then the reasonable accommodation is provided to person. If it's not because it's not regulated anyhow. That's it. Yeah, and now you can ask maybe some questions.
Ačiū labai Guntai Ančai iš Latvijos negalios organizacijos.
Thank you, Ms. Ancha from Latvia. So we still have some questions, some time for questions. So it's high time to ask. I'm Stasė Grishinienė from the General Help Center. Does Latvia carry out any information campaigns for employers to inform employers about the situation and to make it possible for employers to get ready? Are there any information campaigns for employers to employ people with disabilities?
Thank you for your questions. Yes, we have. We have informational campaigns for employers. We have a lot of discussions what kind of informational campaigns it should be. Our last one was with some posters and website where it was said that people with disabilities could be good workers. And I'm not always sure that it is exactly what we need to do. I think we need to explain much more in details, otherwise we have some kind of stereotypes when employers come to us and said, I would like to employ some person with disabilities. And then we ask what kind of, and in general the answer is, I would like to employ a young, nice, handsome man. He should be on the wheelchair, but he should be on a manual wheelchair that looks nice. So maybe it's not exactly like that, but very, very similar like that. And sometimes I have a feeling that the reason of it is these campaigns, because in those campaigns we have a young, handsome man on a wheelchair. So we need to think about it, yes, but we are doing that. But of course, employers also have the possibility to go through the Center of Employment and to take part in the 3 hours training to get more information about disability and way how to employ people with disabilities.
Gunther, I have one question. Do you know if your country has the same kind of legislation as Lithuania or Sweden when it comes to including the conventions within the legislation that Mari described earlier?
We don't have anything said about reasonable accommodation in our legislation, as I said before. So, yeah, that's a very short answer, I would say. But of course, one more problem, what is the difference from Sweden and Latvia? I don't know about Lithuania, but I also think so. That, as Marie said before, in Sweden, inaccessibility could be as a discrimination. In Latvia, and I don't know about Lithuania, it's not a case of discrimination. So it means if I can't go somewhere, and I can't, it's not a discrimination in my country. And I don't know about Lithuania, but I think it's the same. Convention is like umbrella of national laws, of course. And all laws which are now developed in Latvia are based on the ideas of convention. Any other questions? Okay, no?
Panašu, kad klausimų daugiau.
It seems like there are no.
Yeah, thank you.
Dabar kaip tik ir pakalbėsime.
And now it's a high time to speak about the situation in Lithuania. It will be presented by Birutė Sabatauskaitė. She's a lawyer. She's an equal opportunities ombudsperson. She's on maternity leave right now, but still she can't quit working.
Welcome. I'm happy to be here. Everything I'm going to say today is not the official sort of standpoint, because we do have another person, Gita Lygienė, who is acting well, equality ombudsman. So I have quite a challenging task before lunch to look at all the spheres of life from the prism of reasonable accommodation. But the slides the color looks different here. Well, I'll try to not digress from something I wanted to talk about. All right. This is not my slide even. Apologies. Here we go. Yes. So today I'm going to talk about, so you don't fall asleep, all right, before lunch. I'm going to talk about reasonable in accommodation Lithuania, its regulation, also the distinction of reasonable accommodation and accessibility. And then I will look at several spheres: education, then healthcare and employment and public services. So it's not going to be the same presentation as we had about the situation in Latvia. But in terms of regulation, as we heard already, reasonable accommodation is not equal, not the same as accessibility. If we want to ensure, both aim to ensure sort of accessibility, but the obligation to ensure accessibility through universal design or assistive technology is an ex ante obligation, whereas the duty to provide or the obligation to provide reasonable accommodation is an ex nunc duty. Whether we talk about employment or education, it starts from this moment. Let's say the place of work, meaning it depends on the type of disability, so there has to be reasonable accommodation, and therefore we are talking about two Latin terms, ex ante and ex nunc, but this is something I just explained. Now I'm going to talk about the regulation of reasonable accommodation at the workplace. First of all, starting with in 2022, amendments were introduced into the law on legal opportunities, as I said, enforced since August 2022. What does it mean? It's a bit strange wording in Lithuanian, at least, because it says the following: implementing equal opportunities, the employer must take reasonable steps irrespective, that's interesting, of disability. And again, this is a contradiction, I think, to enable persons with disabilities to obtain employment, work, pursue a career, undertake training, including the provision of suitable working conditions. It doesn't mention reasonable accommodation, but it's the same. Provided that such measures do not result in a disproportionate burden on the employer. Up to 2022, there was a different wording of the same law. And it said, including reasonable adaptation of the premises or facilities. And then an amendment was introduced because we do not talk about reasonable premise of facility accommodation. We have to talk about reasonable accommodation of the conditions. So maybe flexible working arrangements are needed, or something else. So it cannot be restricted to just premises. I think the directive, when it was translated into Lithuania, reasonable accommodation was translated as that was back in 2002. It was translated in Lithuania as accommodating the premises or the facilities. I'm not blaming the translators, because we didn't have the vocabulary of terms at that time, the glossary. So let's go further on. The question, is it discrimination to fail to provide reasonable accommodation in the workplace? Yes, I would say yes. And the very law on equal opportunities does not explicitly state that denial or failure to adapt conditions constitutes discrimination, and failure of an employer to comply with this duty constitutes discrimination on the grounds of disability. The good news is that there is a draft law submitted now, which will actually really introduce a deep-rooted definition. The denial of reasonable accommodation will be regarded as discrimination. But what is disproportionate burden? I'm not going to answer this question. I'm not sure whether that should be included into the wording of the text. Likewise, there is no definition what is meant by reasonable accommodation. But as we said in the morning, the CRPD is valid in Lithuania, and it has to be directly, just implemented. And Audronė Daukšaitė-Timpė is going to talk after lunch. And the convention was applied already while meaning analyzing or going into the quire of the complaint. Right. Now, education, the law of education. I will not provide details because of the time schedule, but it's also amendments introduced repealing Article 20 on education and admission to schools. Then, regulation is not consistent, and I see just the same, even though it's not consistent, progressive changes have already been introduced. And also when we talk about the new law on the framework of the rights of persons with disability, as I said, I am not going to talk about the very details, but the law on education, I think the most important changes, amendments were introduced in 2020, but on the 1st of September 2024, actually, the one of the recommendation from Lithuanian Disability Forum was that to introduce the concept of reasonable accommodation schools, and we're talking about admitting children with disability into mainstream schools. So until September of this year, we had this law saying that children with disability, if quite often were denied enrollment into mainstream schools, and they had to attend some other establishments. So now, of course, it depends on resources and goodwill. And the law on equal opportunities does not regulate admission to schools. It just speaks about non-discrimination. So now the law on education says that a school which for objective reasons is unable to provide pupil proper tuition, so it actually keeps changing, the law on education. And recent changes were introduced in June of this year, and Now, part 10 of Article 29 says, yes, if a school cannot, due to disproportionate undue burden, it cannot actually provide reasonable accommodation to a pupil. But I was confused while reading this law. But then the school can actually offer some other establishment. So what happened? What actually we denied, we deleted this discriminatory notion and we introduced something else. It's a different wording, but it raises questions as to its application and implementation. So when dealing with complaints, what message do we send to families raising kids with disabilities? So how about admission of these children to mainstream schools? And I see here, when we talk about disproportionate and undue burden, on the other hand, about non-discrimination of people with disabilities. So I have not included the whole extract, but then it has to be discussed with the parents. Also, two options are available. Other schools could be sort of suggested, or also there should be a discussion how to ensure a reasonable accommodation for a certain pupil. I cannot give you now the definite answer, but when we talk about reasonable accommodation, we see also it's also safeguarded in Article 34. But this is the most important provision, which is questionable to me. On the one hand, it's kind of positive. On the other hand, it's I would say a step backwards. I can only make guesses. Why? Because schools claimed and directors claimed that they are not ready. It will be too disproportionate a burden. But on the other hand, if we don't start doing that, we'll never be ready. So maybe it's better to do something, to make mistakes, to learn from mistakes, and go forward. And then let's talk about some other sphere. This is the sphere of goods and services. It's not regulated. Now again, there is a adaptation of conditions, goods, services. It's not explicitly regulated, as I said, but we have an Accessibility Requirements for Products and Services Act, which will be enforced from 28th of June 2025. We're talking here about accessibility, universal design, non-individualist adaptation. So it's not reasonable accommodation, it's more accessibility. The law on the framework for the protection of the rights of persons with disabilities actually establishes the principles of fairness and also reasonable accommodation. Now, so equal treatment, so there's an important exception to the principle of equal treatment, which was non-existent before, meaning that in certain cases it was said that equal treatment regardless of gender, age, disability, etc. But nothing was said that in some cases more should be done for persons with disability so that they don't feel discrimination because conditions are not equal. And so meaning the same principle, it's said that only in cases where the conditions or opportunities afforded to a person with a disability identical to those afforded to other members of society are ineffective, shall a person with a disability be provided with more favorable conditions. I would criticize that. I don't like the wording favorable conditions. I think it should be worded as meaning delete doing away with any obstacles. And well, let's go further on. And the law on the framework for the protection of the rights of persons with disabilities also establishes the principles of fairness and equal treatment and reasonable accommodation. And I think this is very important. But again, there are no details given about this principle of reasonable accommodation, and meaning it just, we read the law and we read about adequate accessibility is not specified, but it's more about housing adaptations, technical adaptation of cars, etc. So there is no universal, actually, regulation. And reasonable accommodation is also understood as the definition is given. So I think progress was made, significant progress in 2019, and I think the reasonable accommodation should also be included as definition in the law on equal opportunities. But as I said, progress compared to the analysis 2019 is obvious. And as I said, we should, I think it's necessary to talk about reasonable accommodation in all areas: education, goods, services. One of the most challenging questions to me is the regulation of reasonable accommodation in the sphere of goods and services. Also, I think it's very important to shed a light on or to make it mandatory that denial of reasonable accommodation should be understood as discrimination. And then all employers, all public institutions actually should understand, reading the law, that it's not actually an option, it's a mandatory obligation to provide reasonable accommodation. So, yes, refusal to provide reasonable accommodation to persons with disability constitutes discrimination. This should be crystal clear. Now, regarding this disproportionate burden, I think we should still discuss it and provide a sort of not finite criteria, not a definite list of criteria, but some guidelines, meaning very often lack of goodwill can be sort of expressed as disproportionate and undue burden. And after lunch, we'll discuss some practical cases when a person loses while working sort of a capacity due to certain reasons, and the employer refuses to change to either the nature of his work or the working conditions, or to maybe look at the functions, and he says that no, this person is no longer fit to work. Maybe the person cannot stand during the working hours or sit. So I think we should consider establishing indicative, not exhaustive, but indicative criteria for disproportionate burdens. And of course, continuous education is needed, and awareness should be promoted about reasonable accommodation in all areas. Also, very often reasonable accommodation is understood only via the prism of physical accommodation, and they understand it in a very simplistic manner, meaning providing information or putting information, and if there is no possibility to provide information in Braille or some other ways, no, actually we should include all areas of life and make everybody understand what we mean by reasonable accommodation. But the more accessibility provide, the less we should probably focus on reasonable accommodation. But I'm not saying we have to stop providing reasonable accommodation, but these two are interrelated. Any questions to Birute? No. No questions, no comments, so thank you very much, Birute. Now we have a lunch break and we come back 1:30, and then we'll talk about the situation in Lithuania, and we'll have a discussion as to the future steps in Lithuania to make sure that the situation improves. Thank you and bon appetit.
Sveiki sugrįžę, sveiki
Welcome back after the lunch break. I hope you enjoyed your lunch, but you will not fall asleep. Now let's move to the second part of the forum. It will focus on the discussion of the national context in different fields. First of all, we'll listen to the presentation of Audronė Daukšaitė-Timpė. She'll tell us about the principles of reasonable accommodations in the Equal Opportunities Ombudsperson. And at the very end of her presentation, she'll tell us about the gaps of regulation, both in the national and international legislation. We heard a number of presentations telling us about national and international legal regulation. My presentation will be more practical. I'll tell you about the work of Equal Opportunities Ombudsperson and about our daily practice in investigating complaints and consulting people with disabilities. I will start from some statistics. This year, Sprinter carried out a service initiated by our service, and the survey shows people still lack legal education. 1/3 of people are not sure whom to contact in case they face a breach of their human rights. And awareness is mostly lacking for people living in rural areas, people who get lowest income, including people with disabilities. Such people don't know how to defend and protect their rights. Not everybody understands what a breach implies. When asked which groups are mostly discriminated against in Lithuania, people identified people with mental and or intellect disability and people with disability. So our population, our people identify disabled persons as those experiencing most instances of discrimination. Therefore, we should discuss what should be done at the legal regulation level. The statistics reflect in the activities of the Equal Opportunities Ombudsperson. Each year, around 400 people contact us on the issues of disability. People seek advice, ask for referral to the relevant institutions, and to give some information. Most often, people complain or ask for information about the field of goods and services. They complain about the inaccessibility of such locations. Very often people complain about public and municipal authorities. Their facilities are inaccessible, impossible to get information, inaccessible buildings. Inaccessibility in employment relations is another common field. People complain about discrimination in employment, harassment, and so on. And the last relevant area is education. But we have some other ombudspersons who deal with the complaints in relation to children. Now I'll tell you how we handle complaints concerning disability and what is helpful in such investigations. A ban on discrimination is set out in the law on equal treatment. It covers 6 areas of relationship, and the law imposes an obligation of non-discrimination on employers, providers of services, education, institutions, institutions, associations, organizations, public and municipal authorities. So in terms of regulation, Birute has briefed about it. First of all, we should speak about the law on equal treatment. It lays down provisions on the duty of accessible environment, on reasonable accommodations. Our law says employers must provide reasonable accommodations for persons with disabilities. Other laws do not speak about such requirements. Our office investigates complaints and relies on such obligation. It interprets the concept very broadly. The source of this obligation is the CPID Convention. And these obligations are interpreted on the basis of the spirit of the Convention, as well as commentaries by the UN Committee. We have developed specific practice in applying the provisions. We also rely on the case law of national courts. In case people go to court, in case our decisions are appealed against, courts establish and develop precedents. However, case law is not very consistent and uniform. Very soon I will tell you about some practical examples. What else is important and used as a source? The law sets out the concept of indirect discrimination. So, as in the case of reasonable accommodations, this principle requires to ensure conditions based on the person's needs. Similarly, in indirect discrimination, we imply the same treatment with respect to all persons. In practice, such treatment can restrict the rights of some persons. In terms of discrimination for disability, this becomes very important. And this facilitates investigations by our office. Moving the burden of proof on the offender. It is so based on the law on equal treatment and some other laws. If a person contacts our office, the court or labor disputes committee, the alleged offender must prove no breach has been made. It facilitates investigation of situations when offenders are unwilling to provide information and explain why discriminating activities had been carried out. So it is enough to make a finding of discrimination. In investigations, we assess whether the principle of equality has not been breached. We clarify if the person with disability was given opportunities to work, study, or engage in some other activities, as well as make use of publicly available conditions like to go shopping, go to entertainment, and so on. As mentioned by Birute, I will focus on two obligations set out in CPRD, namely accessibility and reasonable accommodations. The obligation of accessibility mostly relates to groups and reasonable accommodations to individuals. The first is the ex-ante duty before the person concerned submits a request. request. In fact, there are standards set out in laws that service providers must follow. In Lithuania, we have an issue. It's not unique for Lithuania. It can be observed in other countries as well. Normally, courts rely on the requirements set out in effective legal acts. But if buildings are old, technical regulations are not effective, and it implies it's not easy to justify the necessity for reasonable accommodations. This obligation is ex nunc. Standards of accessibility can be an indicator, but they are not necessarily mandatory. Our office relies and assesses accessibility standards first of all. We see what regulations are in place in our laws and construction regulations, for example. If such standards are not enough, we consider the applicability of the obligation for reasonable accommodations. If a store is not going to make any repairs, it must be made accessible to people with disabilities because the CPRD imposes such an obligation. Similarly to the law on equal treatment and to the principle of equal opportunities. Let's move to practical examples. The first relates to the polyclinics of Kaunas. Egidijus briefly spoke about it, and it reveals the interpretation by courts of reasonable accommodations. So, in the case of Kaunas polyclinics, an applicant complained his minor disabled daughter was unable to access the polyclinics because it was not accessible. And the polyclinics explained as follows. Their building had been built long ago. The necessity to adapt is not set out in laws. The same services were available in other treatment facilities. The Office of the Equal Opportunities Ombudsman found out the polyclinics was discriminating against this particular person because of disability. The polyclinics appealed against our decision to the court. Eventually, the case reached the highest instance, and the court revoked the decision of the ombudspersons. The court relied on the arguments. The service did not find out whether the person could have received services, alternative services at home, for example. It looks like the court shifted the person, the duty of proof on the applicant. The court agreed the duty was not imposed by effective construction standards. However, an exception from accessibility could not be justified. And the service had to investigate, the office had to investigate the case. And eventually it was concluded the polyclinics discriminated against the applicant. In this particular case, the person needed neurologists, which were unavailable at home. And the good message was, over the 2 years of litigation, the polyclinics just set up all accommodations. So it was a positive outcome for people with disabilities. But the office had to compensate litigation costs. So both institutions get funding from the state or from municipalities, but we had to compensate the respondent for their litigation costs. It was a matter of our ambitions, and our mission was to ensure the rights for disabled persons with disabilities. One more example. An applicant with mobility deficiency contacted us and said he could not get inside the study qualities assessment center. The building was not accessible, but the staff took documentation outside while the applicant was sitting in the car. And the person complained he was unable to enjoy the same avenues. Later claimed compensation from court. And the court ruled. By the way, the decision was rendered in 1 year later, and it ruled the center did not ensure the same possibilities for services in the same way as for other persons. In addition, the center had not informed people with disabilities about all options for getting the services. And the person was not supposed to prove why he had not chosen alternative services. A person with disabilities must have the opportunity to use all service provision mechanisms possible. The case of the polyclinics of Antakalnis, the applicant had just a vision impairment. However, the reception of the polyclinics had only touch screen registration facilities, and the applicant could not register on her own. She had to get assistance from other persons in order to get the service. And our office contacted the polyclinics and inquired how opportunities to register and get doctor appointments would be ensured. The polyclinics took steps to adjust registration facilities and to meet the needs of people with visual deficiencies. In this case, it seemed the system was very modern, enabling registration. However, it was not adequate for people with sight deficiencies. And one more example from the field of employment. I'd like to show you how this obligation applies in employment relations. The applicant had a hearing deficiency. She received an invitation for a job interview. She informed the potential employer she had a disability but could read from lips. Eventually, the bank rejected the applicant. It explained the job was mostly to deal with internal processes. However, a large number of team work was envisaged. So our applicant was able to do her job, but because of internal meetings, it was refused to consider her nomination, her application. Our office concluded the job functions mostly involved internal processes using computers. And now, in terms of the distribution of the burden of proof, the bank has not proved that the applicant would not have been able to carry out the functions assigned. It was supposed also to prove that the bank was unable to modify the working mode. Now, and it wasn't the case. The bank wasn't unable to offer reasonable accommodations. In this case, the bank has failed to meet its obligation in the field of employment. And the latest, one more example in relation to pickup parcel lockers. The applicant bought goods. The goods got delivered to parcel lockers. However, she was unable to pick the parcel because of touch screens. We informed the parcel company about the shortcoming, but they replied accommodations were impossible. They suggested the applicant should use the help of her family. During the investigation, we contacted the Union of Blind persons. During such investigations, we seek expert reports very often. We implement the provision of the convention saying people with disabilities should be involved and speak whether a specific situation meets their needs. That's why we contacted the association and other organizations employing experts. They are in a better position to explain whether a building or a service is accessible to people with disabilities. So the union replied, indeed, people with visual impairment were unable to use parcel lockers. So we identify a breach of equal treatment has been committed because people with visual impairment were unable to use such lockers. We recommended installing and implementing alternative technologies. Other delivery services companies had already some positive examples in this case. And one more event relating to the ethics committee of the municipality. Our applicant had a mobility disability. She complained the commission refused holding a meeting remotely. The building of the municipality was not accessible for people with mobility deficiencies. And the municipality replied, requests for remote hearings can only be submitted by members of the commission, not by anybody concerned. And our office found the chairperson of the municipal committee, being aware the meeting would deal with the issues important for the applicant, was supposed to ensure access for the complainant. And the meeting had to be accessible for the applicant, especially bearing in mind her disability. It was about some elementary accommodations, just about arranging a remote meeting to enable the person to speak on the issues of concern. I'm coming to a close and I'll give some conclusions. There are different examples available on the website of the ombudsperson. Just in general, my intention was to show to you it's not in all fields the principles of reasonable accommodations work well. The Office of Equal Opportunities Ombudsperson deals with such complaints, including complaints about accessibility. Complaints about accessibility concern a larger group of persons, and we investigate complaints and give recommendations. Eventually, it changes the life of many people. The provider of the service has an obligation to make some changes and ensure the accommodations. The ombudsperson does not limit herself on legislative requirements. She makes recommendations how to ensure equal treatment. We investigate realistic opportunities to get goods and services. We must improve not only legislative regulation, but also increase awareness of our people. If people know what rights they can exercise, they will be more active in complaining and seeking help. It will increase the possibilities to us and to service providers to meet such needs. Thank you.
Palaukit, gal dar bus klausimų?
Just stay for a while. Thank you. Maybe there will be some questions. And thanks to Audronė Daukšaitė-Timpė from the Representing Equal Opportunities Ombudsman's Office. Very interesting presentation. Question, please. Very interesting it was. I'm Eva Petkutė from the association Dementia in Lithuania, and our target group encounters discrimination of inaccessible services, let's say going to the dentist's clinic. And I think when we talk about legislative framework, dentist services cannot possibly be provided at home, in home setting. But what I want to say is, when you have to do something, you are at home, you are suffering from pain, and this sort of understanding who to address, where to go, means, you don't know which resources are to use. How should a person, handle the situation, and how long does it take, let's say, and how many resources are required? How long does it require until the complaint reaches your office? Thank you. Now, the first question. What we advise is just address or contact the service provider, because an individual sometimes lodges a complaint to our office without actually trying to somehow resolve the situation. So if there is goodwill from the service provider, maybe there should be there could be some alternatives found ensuring reasonable accommodation. So the first step, asking contact with the service provider. And if it doesn't help, then of course, lodging a complaint to Equal Opportunities Ombudsman's Office. But yes, sometimes persons are intimidated or feel embarrassed, particularly we're talking about employment field. Usually we investigate the complaint during the period of 3 months. If it's a complicated case, or if there's an appeal, let's say, made, then it could encompass 2 or 3 years even. Of course, we have to make a detailed analysis of the situation, and it's done by the lawyers of our office, and then we contact the service provider, and then we actually ask for examination conducted by the experts, conclusion of the experts. And of course it takes time, but it's meaningful, meaning to get the conclusions. I want to mention that the lodging a complaint is quite simple. Nothing out of the ordinary. Not a lawyer is not even needed, meaning a person has to describe the situation and the resources. You were talking about resources, so it's actually the office resources. And in the primary stage, maybe Audronė could offer some more details, but I think yes. If we talk about employment sphere, so maybe it's probably a different matter. But otherwise, the complaint, the procedure of lodging a complaint is quite simple, and you don't have to have some legal knowledge. And if a person finds it difficult to fill it in, then our employees or the office can help them. So it's not really, it doesn't require a lot of resources, that step. Thank you. And my question is, have you had complaints focused on inaccessibility of cultural services, when a person cannot access cultural services? Where do I start, I wonder? A more interesting case, maybe, meaning a more complicated case. Yeah, I could hear the prompt. Anykščiai recreational services. The lift which is not functioning, or TV tower that we had, when persons with disability were restricted, they couldn't get up. And when I asked why, the explanation was that in case of evacuation, let's say if there is a fire, we wouldn't have needed resources. And yes, we went to the TV tower because it was a serious case, and we were shown evacuation staircase, very narrow, winding, and in case of evacuation it would be difficult. But then we came to a compromise that on certain days they would have firefighters sort of on duty, and they would help carry down a person with disability if there was a need. One more question? Just a comment. Yeah, you mentioned the evacuation, and it's not the first time I hear that. What should we do then? Just in case of evacuation, if that's needed? Yes, but yes, this is important for many public just services, meaning on institutions where there are elevators. So how should maybe we should think about some algorithms or what? Because the service providers usually mention that kind of a lame excuse that yes, in case of evacuation they will not have the resources to handle the situation. Yes, Indra, I think not only the accessibility of the service is important, but also information about the service, meaning people with disability have to know well in advance, let's say, about this TV tower, visual, audio signals, etc. And nobody was thought of that before this question came up. I want to react that our Lithuanian Disability Forum was actively involved. I remember there was a message that was in 2017 or 2018, yes, that people with actually mobility, disability could not access TV tower. And somehow this process is not actively communicated. We talked to them and we found a way, we found a solution. I do remember the situation. my colleague in a wheelchair also was with me, and he said, yes, I made a proposal to my wife here in this place. So maybe there's no information because, as I said, we found the solution. Yeah, thank you very much. Very interesting. Yeah. Let's move forward. And it's my pleasure to give the floor to another speaker who will talk about the sphere of employment and meet Jurgita Kuprytė, head of the Social Employment Service, SOPA. Thank you. Thank you for the invitation. Take part. And in this public forum, it was very interesting to listen to all the presentations that I heard. My presentation is not about, it's not an overview of the situation in Lithuania. No, it's more about our organization. And it's about the experience. And we actually are an organization of social employment for people with disabilities. And I'm going to talk about the way we understand reasonable accommodation and what should be important, that meaning a broader perspective is needed. So 2 out of 3 persons with disability are unemployed, and this figure, regardless of all the efforts, is changing, but not that significantly. So we have about 100,000 out of 100,000 adult persons, working age, only 30,000 persons employed. And there are lots of reasons explaining that. One of them is, well, lack of reasonable accommodation. When we think about that, again, just a reminder that it's a much broader perspective or view. And when we talk about recruitment or selection processes, and also about the workplace, both in terms of physical reasonable accommodation, but also in some cases reorganization of job functions or performance. Also initiation at workplace and support provided, and depending on the type of disabilities, are critical to make sure that a person can stay in employment. Now, when we talk about the selection or recruitment, so the situation is that employers usually post in social just platforms job adverts, and they are think that the people who will be interested will come up with their applications, but it doesn't help people with disability sometimes, because about every day you can find about 200 job adverts in databases, and you have to find them, you have to scroll through them, you have to come up with applications. So we're talking about the intellectual disability or some other disability. This is a complicated task, and not all people with disability can read those job adverbs. And if there is no alternative, let's say text, if it's just an image, even though there is a description, so some people, let's say with visual impairment cannot understand, or persons with dyslexia find it difficult to understand, even if we talk about simple sort of tasks or jobs. The language in those job adverbs is not that easy to understand, and also the information about the task to be performed is lacking, is scarce. Quite often those job adverts are only written in general sort of features, but it's difficult for a person to understand whether physical, intellectual capabilities or skills will allow a person to take that position. it's not clear from the description. And when we talk to the employer, they say, oh, it's a simple sort of a job. Yes, but when you look at the job adverb, no, it seems quite complicated, quite sophisticated. So I think if, the employer should think about that. Think whether the advert really attracts attention, encourage applications by people with disabilities. And one more thing, people with some types of disability can react negatively to the job advert, which requires just advanced skills in talents, etc. And just imagine a person who has gone through depression lately will probably not even make an application because of low self-esteem. So these epithets should be avoided. And also is non-verbal language valued. So these are the job adverbs that we usually see. And when we talk about jobs which could be performed by people with various disabilities, we have to think of that. Now, the job interview, it's also what is important. The purpose of job interview probably is not to actually reject those who are not suitable, but to disclose the potential of an applicant. And employers, on the other hand, they, I think, intentionally will cause some stressful situations just to check the reaction, how a person deals with stress, etc. And people having various challenges will fail this job interview because they feel stress. And if there's additional stress caused, just imagine, the situation can be difficult to handle. Persons with autistic spectrum also find it difficult to disclose their potential. They cannot boast of their skills just because they are intimidated. They feel tension when exposed to unfamiliar situations, and and they will not look employer in the eye. They will be too intimidated to speak. So it's important that the employer understands that these people can be there's a wide range of different disabilities, and just to understand how persons react. And I think most important is to those who find it difficult to verbally communicate, we have to find other alternatives. Tests, let's say, they also, they are a cause to stress. So that's about job adverbs. And here you see the example from the first Pancake social enterprise, how they recruited their staff, and they employed people with disabilities, and they actually offered the jobs to people who had no education, no experience, nothing. But what they did was to organize, some practical work for a couple of months, so those persons test and try all the services needed, meaning servicing the customers, make coffee, clean the tables, wash up. So all of them tried different tasks which were needed in this social enterprise, and that was performed in safe environment with support, and so the employees understood which person is strong in which area, and or maybe they even failed, but it was the answer as to the potential skills or abilities of a person. So this was a much more efficient person compared to job interviews. Another example, with the company, another company, we actually familiarized ourselves with the company, and I went there and I talked to its heads, and then we arranged a visit with 6 or 7 persons, and it was an on-site kind of training, and also an opportunity to test themselves whether they will succeed, because they had to assemble certain parts following the instructions. This is not meaning motor skills, fine motor skills, etc., and the ability to follow the instructions, to read. Yes, some monotonous work. That was kind of scrupulous work. A couple of hours were needed, whether the persons would find this job attractive or boring. And then it went well. And the company selected several persons, and then those selected persons, so it was from the grassroots selection. Only later the job interviews were arranged. Now, when we talk about reasonable accommodation, it was already mentioned that physical environment, of course, is important, but technological accommodation is also important. It's still complicated, at least for persons with visual impairment. In consultation centers, in call centers, when they have to provide services to customers, and but international companies, they have standardized international IT systems, and it's complicated for persons with visual impairment to understand it. The companies do not know how to provide reasonable accommodation, and they don't ask the persons with visual impairment what is needed to make their job possible. Also, working time is very important. Persons with psychosocial disability, they have to take medicine, and they cannot start working in full gear, so to say, from 8 o'clock. They are more sort of robust in the second half of the day, so maybe they should be allowed to start working for 2 hours, prolong the time, and meaning a person having been unemployed for a long time, or maybe having suffered from some certain disease, finds it difficult to start working. So maybe 2 hours would be enough for the beginning, but it's not that easy to sort of come to a compromise with the companies regarding the working time or the work schedule. Remote working is also complicated. Now the market, we see, requires that persons who they have to learn fast, which is difficult for persons with disability, and so meaning we also have to come to understanding regarding this learning processes. Remote work is also part of our everyday life, but not all persons with disability enjoy that. They have been sitting at home for such a long time that they would rather go and work physically. Now here you see the example from Rimi supermarket. They installed cashiers desks, and there was reasonable accommodation, but we had this candidate Saule, and we went with Saule, that's her name, with the applicant to the company, and she moving in a wheelchair, so she tried to go through all the parts of the supermarket just to test where everything was okay. And when she was employed, she was living not in Vilnius, so the company even arranged a transportation arrangement, and also flexible working arrangement was ensured for her, meaning the company actually, well, I think this is a good example of reasonable accommodation. Another example in the contact center with the blind persons, or rather with the visually impaired persons, a group of them. We went to the company to get to know them, and prior to the recruitment selection, we had to make sure whether they would be able to work with the systems there, and the answer was positive. Then selection interviews were held, but then we found out that a person with visual impairment found it too difficult to go through various sort of windows on the dashboard and to talk to the client. So the company carved certain functions. So this person was given the task of writing some letters rather than provide counseling to clients, because it was a bit too difficult. And meaning that was reasonable accommodation provided by the company. And quite often this reasonable accommodation could be compared to a trip or a journey, when the company asks what they should do to be fully sort of accommodating. We cannot talk about that. It can be done overnight. It's probably a step-by-step process, but it's good when we see the company is ready to do that, and carving out functions, meaning when people with disability are not required to do all the functions, but some functions. I would like you to watch a video clip. No sound. All right. Allow me to talk about it. What do I mean? No sound. Job carving. This is a measure when from a lot of functions, certain part of the functions are carved out so that a person with disability could go on working. Here you see a person checking the price tags, whether they comply to the prices in her list. And this is part of the tasks of a person working in a supermarket. Just one part of the functions. So we made an arrangement with Remy that this person should only be required to fulfill this part, these functions. She is autistic, and communication or some more complicated things would be a bit too complicated, but she's very good at noticing the details. So this and we talked about her case with the Remy supermarket and said that yes, she's very cautious, she's very good at noticing all the details. So what can we do? Because Remy didn't have such a position then, and it was individually sort of created, kind of tailoring her needs, and they were ready to have such a position so that a person is favorably inclined. And they said, okay, let's see what she could do that. And we were given a list of the functions of what such employees asked to do, about 20 functions. And when we carved out certain functions and we checked what this person could do. Also, very important is the support given at work. If you leave a person with disability on her own, it would be next to impossible, meaning scanning functions, printing, communication skills, because in this case, communication was a challenge, particularly with customers who keep asking, where is milk, where is bread, etc. So we had to train her to provide appropriate answers to the customers that they better address another colleague. So I would say that it helped. At the beginning, she was given intense support, but later on this intense sort of subdued and it was not needed. And she became quite independent in performing her duties. So I think this is all about reasonable accommodation. By reorganizing certain jobs, certain functions, it's part of reasonable accommodation. What else did I want to tell you? That I don't know if it's possible to put on the slides everything that's important, but of course, there are many people and their needs are individual, and so there is no one solution for all. And also, here you see a slide related to regulation, but so these are challenges. Maybe we'll talk about those challenges in discussion. There's a lack of consistent regulation. Also, the services are fragmented and no actually uniform approach for the challenges, that there is no support system for employers. Some of them are ready, but they should be supported. They should be explained, and this is a gap still. And the other things, NGOs should be more involved. There's no flexibility, and there's lack of communication. Thank you very much.
Jurgita iš tiesų dalyvaus ir diskusijoje, jeigu turėsite.
Jurgita will join our discussion. Unless you have very urgent questions, please save your questions for the question and answer session. Now I'd like to give the floor to Indrė Širvinskaitė. She's president of the Commission for the Monitoring of the Rights of Persons with Disabilities. Hello once again. My idea was to overview most important elements because of the time shortage. All the issues cannot be discussed. The principle of application is horizontal, and I'll try to fill the gaps which still exist. At the same time, I will make an intro to our discussion. We are behind schedule, so I will not repeat the same ideas. According to Article 2 of the CPRD, discrimination on the basis of disability implies any distinction, including denial of reasonable accommodation. Article 5 says, in order to promote equality and eliminate discrimination, states shall take all appropriate steps to ensure reasonable accommodations. As Professor Ruškus mentioned, it is in particular relevant in certain fields. Applicability is horizontal, but it has a specific mention in several articles, including Article 13 in relation to the right of justice, in Article 24 in relation to education, also Article 27, which speaks about employment conditions. In general, as mentioned before, accessibility ex ante is possible when we plan the accessibility of old buildings. It applies to universal designs and new buildings. Ex nunc is as of now. It is about reasonable accommodations, which is the second side of the same coin. It is very important, and it echoes with the President's initiative. We have obligations based on the UN Convention. The UN Committee issued recommendations for Lithuania, and it expressed a deep concern that the state does not consistently apply the concept of reasonable accommodations in relation to the principle of non-discrimination. Reasonable accommodation embraces both accessibility and non-discrimination. Both elements are very important, and the committee recommended monitoring and recognizing denial of reasonable accommodation as a form of discrimination on the basis of disability. The committee, in one of its commentaries, offered interpretation of what elements, actions, and course of implementation should be taken. And it explained how accommodations should be implemented. First of all, barriers should be identified and removed, meaning the barriers for communicating with the relevant person. In addition, it should be assessed whether accommodations are possible in practical and legal terms. Thirdly, it should be assessed whether accommodations are necessary, whether they are appropriate and necessary. And eventually, it's necessary to assess whether the accommodation gives rise to an appropriate and unreasonable or undue burden. The committee also said it's important to focus and examine not the financial burden of one entity, but the whole single whole, for example, one particular state or one particular company. It's important to achieve the main objective, namely to promote equality and eradicate discrimination. In terms of burden, there are some important points to take into account. The professor has spoken about it already, and the guidelines are laid down in the commentaries. Very narrow criteria are not impossible because fields differ and different situations can come up. It depends on the area, on a particular need and services. In general, the guidelines are applicable and they are just of an abstract nature. Other principles have been already discussed. Now let me speak about the practical application in different fields in Lithuania. Education has been described already. It is regulated by a couple of laws. You spoke already about the law on education. Yet the area of general education is very distinctive because accommodation of education is an obligation stemming not only from the CPRD, but also from other documents. The United States note Engaging Education Act is the fundamental piece of legislation. We also have the law on vocational education, the law on non-formal adult education, and the law on continued education. Recently, we saw many new provisions introduced in this law. In addition, we have the law on science and studies. In practical activities, I had to apply the concept established in this law. I remember when working at Vilnius University, we tried to design the system of reasonable accommodations. This particular concept is used on the international level in order to make it possible persons with disabilities to study. Our law on science and studies does not define such a concept. It does have a part of the general obligation of non-discrimination. It has one additional provision which allows for students with disabilities to take tests and get credit in alternative ways. So such provision is in place, but it is very limited and applies for tests, examinations, and similar credits. At Vilnius University and in other higher education schools, internal procedures had to be drawn up. First of all, a needs assessment is made. It is done by a disability coordinator. Eventually, recommendations for the faculty are made, and the faculty transfers and communicates the information to teachers and lecturers. In this case, we applied the convention directly. We passed an in-house legal act. It was a particular description describing how this provision should be implemented. We did face some problems. Based on the principle of goodwill, we could work. But in situations of disagreements or disputes and potentially undue burden, it was difficult to work. Universities and faculties enjoy much autonomy, similarly to teachers, as to the methods of teaching. And it eventually leads to restrictions, and sometimes students suffer. For example, university councils can issue some unfavorable decisions, and there are no countermeasures. It seems it's okay to apply the principle from the bottom, but we must be very careful. One more observation about health care. People with limited mobility have a description of a procedure how persons of limited mobility can access healthcare institutions. The document speaks about the accessibility of information and some other important fields. The description is only of recommendatory nature. Some other examples would be useful. They come from New Zealand. I rely on the publication from Zealand, reasonable accommodation guidelines. In the field of education, for example, at a school, it's not allowed to eat during lessons, and students with disabilities need and must eat when necessary. And the school can use an exemption and allow the student to eat if necessary. One more example, a deaf student asks for pre-recorded lectures and their captioning. Technical limitations do not allow it, but the faculty provides and offers written transcripts, which is very helpful for deaf students. Blind people must use computers with the screen reading function during tests. And it is possible to take such needs into account. All students use by hand, but blind students can use computers with the touch screen reading function. The screen must be on and visible to the observer. Examples from the field of health care. For example, at a polyclinics, the second floor is not accessible by a wheelchair. Some doctors' rooms can be moved to the ground floor. Very often solutions are about algorithms or describing some processes. Reception rooms should also respond to the needs of disabled persons. So responsibilities must be clarified inside institutions and how accessibility could be improved. One more example from the health field. It is difficult to move inside a shopping mall in a wheelchair. It's possible to move shelves and cash desks to make more space. It would be good for the needs of other persons, for example. A blind person cannot see price tags on goods, and it's difficult for him or her to shop. A shopping mall can complain about a undue burden, may claim there are not so many blind persons. And in such cases, a shopping assistant to accompany the blind person could be a good solution. And if the person finds it acceptable, the principle of dialogue can prove to be very helpful. It can lead to solutions to implement different options towards a dignified experience. Reasonable accommodation does not deny an obligation to increase accessibility if it is lacking or missing. As a way to compensate, we can think about general accessibility standards. If a particular person needs access to the building, some alternative entry or some other option should be offered. And the state, as well as individual sectors, should think about such opportunities and possibilities as much as possible. So that's it from my side. And your questions are very welcome, and you can raise your questions, address your questions during our panel discussion. Many thanks to Indre. Now a break of 15 minutes, and let's come back 5 minutes after 3. Let's come back at 5 minutes after 3.
Sveiki sugrįžę jau į paskutinę dalį, liko mūsų patys ištikimiausi, tai aš tikrai kviečiu pasidaryti tokią kamerinę aplinką ir
It's good to see you during the discussion, those who have most stamina and who are still here with us. And we would like the discussion to be alive. I'll be talking about possible ways of how to develop reasonable accommodation in Lithuania, where we should start. And we heard a lot of information today, what is meant by reasonable accommodation, what's the difference between reasonable accommodation and accessibility, and how this principle should be implemented, and that it's important to have coordinated, concerted efforts so that this principle does not only depend on goodwill, but we need some systemic horizontal measures and good regulation. And regulation is not quite sufficient. We need some other support to make the possible implementations to provide reasonable accommodation. And we understand that depending on the type of disability, reasonable accommodation could be different. Therefore, we have invited colleagues from different spheres. And who do we have? But before that, before the introduction, we invite all of you, if you have a question or if you want to come up with an example of reasonable accommodation, please raise your hand. Della will come up to you with a microphone and you will voice your question. But here we have 3 microphones, and I want to ask to take a microphone when you speak. So let's start. Asta Marčiulionytė, from the head of Lithuanian region of State Consumer Rights Protection Service. Ignas Gaižiūnas, who's about to finish his duties as a Vice Minister of Education, Science and Sports. Next is Jurgita Kuprytė, whom you heard today, Director of the Social Employment Agency SOPA, Jolanta Sadauskienė, Head of the Equal Opportunities at Women and Men Equality Group of the Ministry of Social Security and Labor. Next is Indrė Červinskaitė, President of the Lithuanian Disability Forum, and Odeta Vitkūnienė, Director of the Personal Health Department of the Ministry of Health. Nice to meet all of you, and let's start with the initiative to tackle this question. And leadership, probably, it's Indrė who is the leader, and she has launched this initiative. Indrė, how do you see, maybe things will change after this discussion, but what could the model be which could help embed the principle of reasonable accommodation and enable a review of processes in all service areas? How do you see, what kind of regulatory model could help us? How do you see the situation? Seems to me, when I worked at Vilnius University, I also made sure that reasonable accommodation was provided as an international scale, and all the universities work on that. But this year we had a lot of discussions regarding the amendments to the law on education, because there was this initiative to include this concept into the law on education, maybe not in the scope that we wanted it to be included, but still during discussions we understood that even though this concept is very important, few people know about it, and few people really understand the content, the meaning. Maybe in Anglo-Saxon countries, it's the fundamental, actually, definition, reasonable accommodation in the sphere of protecting rights of people with disabilities. We don't have this kind of awareness yet, therefore we have the paradox. In our legal framework, this the concept is embedded because of the convention, but many people don't understand it. And, and of course, people can lodge complaints, people with disabilities, but what we want to see in the future, that no complaints are lodged, meaning everything is provided, reasonable accommodation. And I think, yes, we had discussions in the parliament, because there is no definition of reasonable accommodation as yet. It is only embedded in the framework of the protection of rights for people with disabilities in that law. So when we talk about it as a non-discriminative principle, maybe the law, this concept should be embedded in the law on equal opportunities. And I think it would be suitable because the principle of non-discrimination does not tell us how we should go forward. What criteria should be sort of resorted to? And therefore we have to go through different spheres and look at the gaps in other laws and secondary legislation also should be regulating in a better way, so that all the relevant institutions know that this is an obligation to provide reasonable accommodation. Thank you. And there are plans to come up with guidelines, correct, to help implement this principle in various spheres. Thank you, Simona. I forgot to mention, yes, this event has been organized by the Nordic Council of Ministers, and apart from this forum, together with the partners whom you heard today, together with partners from Sweden and Latvia, we have decided to come up with the guidelines, how this principle should be implemented in different spheres of life. Thank you for a reminder. Now, Jolanta, I want to ask you, please share your experience in implementing the horizontal principles of gender equality, equal opportunities. What are the lessons learned? What should be avoided? And what would really help to effectively implement reasonable accommodation as a horizontal principle? So we would love it if you could share your experience, the way you see the horizontal implementation of non-discriminatory principle. Thank you. Thank you. And I have the active experience of 3 years of work in this sphere. So we are sort of in full gear because the beginning was difficult. Why? Because we had to explain in greater detail what is meant to various institutions, organizations, what is meant by horizontal principle. On the other hand, the competencies were not sufficient, both in public institutions and NGOs. Now, as a success factor, which is important, I want to mention what helped us move forward. We had a very good structure, and I think in the horizontal principle is embedded in our national progress plan, and this is a factor showing that we are moving successfully. And our ministry, social security and labor, is the coordinator. But the mechanism has been created from a clarification of the principle, horizontal principle, to coordinating all the regulation of what the indicators are. So the whole structure and the system has been thoroughly coordinated, and it makes me happy with this initiative and approval of this initiative. But I think we can only achieve success when the whole thorough structure is created and developed. Maybe it's a joke, but if we conduct a test, if we send a letter to ministries and ask them what is reasonable accommodation with 3 options available, I'm not sure what the results would be of that test. So with the horizontal principle, we do that. We hold trainings to organizations. We elaborated guidelines, and also, well, with all the projects coming to our ministry, we looked at that, and we drew conclusions, and all the progress, just measures and activities according to the national progress plan, meaning we couldn't approve at the beginning because there was no horizontal principle embedded. So they had to review it, and challenges, competencies have to be revised, and competences of the heads as well of institutions have to be revised, and this is important. And in the future, we actually will hold trainings for ministers even, so that everybody understands. So it's crystal clear what is meant by reasonable accommodation, because otherwise it would be sad if approval just remains approval without any practical implementation. So in summary, I want to say that practical work is needed, also coordinating the efforts, and we have the agencies appropriate. So again, we have to appoint competent persons. A practical example, meaning we have open email with the questions are coming, how to implement, how to achieve something, and we keep providing answers. So regulation, legal regulation is not sufficient. We have to work with it every day to make sure that the horizontal principle is embedded. Very interesting experience, and I think it's related to advocacy actually in all these spheres, because as you said, legal regulation is hardly sufficient. We have to talk about call center or counseling center, coordinating education, other spheres, and let's say initiative of making information accessible, because let's say if it is decided that certain information is not accessible, but what has to be done? Support is needed. What do you think, Indre? What do you think of Jolanta's ideas, initiatives? I think it's logical, and I support these initiatives. I think, yes, there should be some competence center established, which would help us to make the support more uniform, so that we understand, so that it's concerted effort. And we have to talk about one center, because if we go into decentralization, practices will become different. I am in favor of one competence center, but we still, the center can actually offer advice, but then we have to talk about separate spheres. Let's say the vice minister knows better about the sphere of education, right? And some other competent persons know how things are in the sphere of healthcare. You cannot offer detailed advice being an outsider, and you cannot actually ask to create some structures, for being an outsider. All right, so now I'm going to the sphere of education. What is your experience regarding the regulation of the principle, and how do you what do you think of the significance of this regulations? So the specifics of the regulation of the reasonable accommodation principle in general education system and higher education or adult education system. I think in education we have what Indra was talking about, meaning we talk about inclusive education, about accessibility. Maybe these actually concepts are a bit different. Maybe they don't quite comply to the definition of the convention, CRPD, and but still in 2020, in June, the law on education was adopted, and and also when you look at the secondary education, it's crystal clear that all students are entitled to the right to be admitted to mainstream schools, but then there are individual cases, and we are consistent in our, in improving our physical infrastructure, in adapting all the toilets and washrooms, and also movement, let's say. But when a specific child is enrolled in a school, maybe individual solution has to be taken to help that specific child.
So when a child is at school, you cannot follow him all the time. I was a teacher of physics, but I'm not an expert of disability, so I will get stuck willingly or unwillingly. We need some outside assistance. Let's say we have an autistic child having some sensory challenges. Maybe he needs some headsets or some screens. Yes, we do have professionals who can help. So that's why we cooperated with regional centers and some professional organizations. In my view, that's not enough all the times. I watch lawmaking processes and I'm surprised at times. We get pieces of legislation which disregard people with disabilities. You said we need more focused vice ministers, but in addition, middle range managers are very important. These people generate and draft legislation, so it's the stepping stone. It's middle range managers for us to focus on. We should speak with such people about the meaning, and it's not difficult most often. We must consider such activities, and solutions are not costly all the time. So this is the direction. And during the years of my service at the ministry, I used to be surprised. Some people from a different unit, for example, get some brilliant ideas, or there were some instances of miscommunication. Yes, reasonable accommodations. It's the road for us to move ahead. We submitted our draft. It was supposed to be finished in February, and we saw reasonable accommodations was just should be an all-embracing document. It shouldn't be a way to avoid responsibility or disregard children. Now the ministry believes undue burden can be relied on only in cases of a very excessive financial cost, and the ministry will improve the present draft. Some other options for relying on an undue burden is cultural heritage and also something else. But we cannot just look for excuse speaking about a lack of professional specialists or time. So now it's high time for discussions about criteria, and I'd like to invite you to look through the draft and go forward. We were speaking about general education, but maybe reasonable accommodations are relevant for higher education. Yes, you are right. As you said, we focus on engaging education in general education, but in terms of higher education, we should forget some measures are applicable. We have a plan on social dimension. We have the mechanism for financing higher education, and it should encourage enrolling students with a disability. Yet we still lack statutory regulation. Measures are available, and some other fields are not moving towards inclusive education so fast as general education. Now I'd like to move to the system of health care. How successful you are at ensuring accessibility, what measures would be welcome and are still lacking? Yes, the main value in the system of health is our obligation not to discriminate based on disability and other grounds. We've been on this road since 1996. Our social partners cannot allow us to fall asleep. What we have done, yes, we have much support from colleagues or other ministries. 3 ministers signed a memorandum on the health care of persons with disability. The memorandum is our commitment to consider matters of persons with disability on our political agenda. The Ministry of Health has a group of matters of persons of disability. It's a platform bringing together people who can solve different issues, be it information, accommodation, professional competencies, or instruments of compensation. So it focuses on all matters of concern to our social partners. In 2019, we asked institutions to describe what institutions, healthcare institutions, should be. We see a lack of maturity. Some expect ministerial orders and decrees. Together with the Association for Persons with Disability, we called institutions to orient towards results. Some efforts are insufficient. So we considered some other possibilities how to help remove obstacles to health care. And we have a good symbolic message. Aurimas Pečkauskas, acting Minister of Health, signed 2 orders obligating each institution starting from the 1st of May 2025 to develop a policy of accessibility. Healthcare institutions should stock take their facilities. In addition, they should link it with the rules of licensing of healthcare institutions. In order to get such a license, an institution will have to prove it has such policy in place in its institution. Awareness is lacking of accessibility, disability, and so on. So it is a different set of actions. In case such measure does not prove out, we'll ask our top leaders to look for some other solutions, yet we expect it'll help move accessibility to a different level. We monitor accessibility as well. We have a national cooperation platform bringing together national and municipal level bodies to report about new legislative lawmaking initiatives. So, as mentioned by the colleagues, if you invest your time, if you see value and meaning, you can deliver a result. However, you should not give up and disappoint your social partners. Many thanks, Iveta. Yes, we participate in our monthly meetings. We present our needs. We have accomplished a major survey, but we didn't get any feedback, I must admit. So we'd like to encourage such feedback. We've collected information, we need support, and we are willing to see stakeholders' engagement. Vilnius municipality is willing to see more accessibility. We have a new, just a fresh news. We are willing to consult to make the services more accessible. And thanks for your input. Now let us move to Jurgita and to the issue of employment. We heard a number of experiences. What's the situation and reasonable accommodation look like in the field of your remit? These changes in lawmaking, all those guidelines and consultation centers can help deliver a more meaningful change. The situation is not bad, but there are not so many institutions willing to make changes in the processes. In your view, can our measures help move things forward? Maybe some employers still cling to the old routine. Yes, while listening about education, I thought there are major differences compared to the field of education. We have no stringent obligations and mandatory duties. Employers are not supposed, are not obligated to make accommodations for each job seeker. Yet we need stricter obligations in this area, because it would make employers think what could be done. An example could be about quotas. Starting with this year, the quota of 5% applies to recruitment. Its implementation is not successful yet, as far as I know, but it's a fact, and we see it. It promotes interest and where the first steps could be made. So it's a nice push towards our objective. Our law on employment, for example, does not speak about obligations. It just defines the establishment of jobs or accommodation of work places in order to get state support, in order to buy equipment and make repairs. Only if the employer sees a need, he or she can apply for state support. But such obligations are not mandatory. They are foreseen in the labor code. Yet it's not enough, because the law says in general terms the employer must take reasonable accommodations. So as far as I understand, the changes are brought by an active dialogue with deployers. It's similarly like in education. In the field of employment, the regulation is more abstract. SOPA is a small organization. We are not the only, but there are a few in Lithuania. And I see the engagement by NGOs and professionals on disability matters is lacking. State authorities fail in developing a model of cooperation. The potential has been untapped in the field of reasonable accommodations.
Thank you very much. Just a reminder to the participants that we're looking forward to getting your comments, questions, recommendations, whatever. And while you're thinking of the questions, I am addressing Garza Macharnita from the Consumer Rights Protection Service about your experience in protecting the rights of people with disabilities. Well, we, Consumer Rights Protection Service, we investigate the complaint, and also we conduct the oversight of the market. Now, regarding market oversight, I'll start with a narrower field or scope. It's very important to ensure prevention in non-food product sphere, and beginning with June of 2025, the Accessibility Directive will be enforced, and we have been attributed the functions to conduct oversight of the certain products via online products. So this is market surveillance. Now, regarding the complaints lodged, I have gone through the audit in my head as to which I should say. When we receive consumers' complaints, let's say if they bought a default product or we provided some poor source, we cannot differentiate them into able bodies and the person having disability. See what I mean? So we explain our rules in simple terms so that they could lodge this complaint in a simplified manner, and I think we are quite successful in protecting the rights of all consumers without making sort of distinction as to some specific group of consumers. But when there is a dispute, I do remember that case when a person, it was on the grounds of disability, when the person was denied service, just because the person had a disability and he was denied some service. He bought a ticket, bus ticket. He had to be accompanied by a person who should receive 100% compensation, and the second person was not allowed to board a bus because he didn't have a bus. Sorry, he didn't have a ticket. And so the person, yes, he sort of, his rights were violated, and we took the decision so that the person should be compensated, should be given, provide some remedies. But I think it's very important not only to provide a service, let's say, like private sector provides various services, and socially responsible even sector, but same applies to public institutions, meaning we have to ensure a dignified approach towards customers, including people with disabilities, not only while satisfying their needs, but providing these services in a dignified manner. And let's say a person could not have access to some concert even though he had a ticket. There are quite a few complaints like that, but it seems to me that the people who have a disability, they try to make their matter heard through the cross-section of discrimination. Let's say if a person is not allowed into some premises where the concert is held, so this is a violation of non-discriminatory principle. And where should we start? We think we should start from communication, from being open, and from ourselves. Every public constitution should start from itself to perform its own internal audit, how to introduce the etiquette, so to say, related to disabilities. Maybe it should take example from socially responsible business. We have many successful cases, and so we should follow suit. So in such a way we could really protect our consumers. And from 2025, when we will have this accessibility directive just in force, and we're talking about various or online services and all those equipment, is this accessibility, or what is the preparation right now for this document to be enforced? The preparation is the selection of staff, employees, various discussions, also perusal of this directive, so we understand it in the same manner. Also training our staff how they will have to conduct the oversight of the market, because this is something new. We're talking about electronic services. Time flees, as we know, and now we are going through these preparatory training stages, also choosing recruitment staff who will have to work with this document, implementing it. Thank you. I'm looking at the watch, and if we want to finish on time, just one question. Professor, your question? Dalia, the microphone is needed. Not a question, but just some additional information. The discussion is super meaningful, and we understand that reasonable accommodation is a very, very important concept and a principle. And this is, we have an obligation to provide it. But like I said in the welcome speech, I forgot one article to mention. I was talking about health, but no, I'm talking about Article 13 in the Convention, the right to justice and procedural accommodation, not reasonable, procedural accommodation is mentioned there. Which means what? So I don't want us to kind of neglect or not to emphasize this, because the sphere of justice is equally important. Let's say people with psychosocial, intellectual disability, this right to justice is very important. If we're talking about accessibility to all, yes, staircase, lifts, etc., but we also, there are people who need both this reasonable accommodation, but we cannot neglect the sphere of justice, because it's very important. You were talking about elaborating guidelines, and most probably there will be a publication which will also deal with the justice aspects, right to justice. And it's not only accessibility, but I'm talking about the rights of those persons who are closed in various stationary institutions, meaning not of their own volition, but they, by force, they're isolated there. So, yes, reasonable accommodation is important, but also access to justice is very important, right to justice. If we want to ensure justice to those persons who are closed in those walls of those institutions, this is no less important. Just some additional information. Yes, thank you. Yes, very important insight. One more question, I see, or comment maybe, or comment, if I may, to something a professor has said, and it's made me happy that you mentioned this topic, because we plan work in advance in President's office, and in spring we plan to hold an event on the right to justice, and we're going to deal with this topic because it has to be admitted and recognized that people with disability encounter challenges in enjoying their right to justice, and it's very difficult for them to protect their right to justice. And we, meaning the community of lawyers, have to really contribute a lot to make sure that they enjoy this right to justice. Thank you. If you have further questions, please raise your hand. And now we're coming to the most important question. Where should we start? So we announced a certain beginning, but Indra, I'm coming back to you after all the statements made. How do you see the situation, maybe in a different light? What could the nearest steps be, or should they be? I haven't seen the new version submitted by the president, and I will read it when I go home. But meaning this submission by the president regarding, this is maybe symbolic, regarding the definition of reasonable accommodation. Maybe symbolic, but very important, because first of all, we have to do that. Then I think discussions will be held, and during the term of office of the upcoming parliament, we have to talk about the regulation of this principle in all the spheres, and also secondary legislation. And thank you, Professor, for mentioning this justice aspect, because it was difficult to include it today. I thought there was a moment when they should include it, but this is an even broader, field, and it's not only reasonable accommodation, but also capacity and incapacity and the other factors. So we hope we'll pursue this close cooperation in the future, and we'll talk about right to justice. And we, as Lithuanian Disability Forum, or the Commission for Monitoring the Rights of Persons with Disability, as a mechanism, we're ready for cooperation. And I think not regulation is the most important thing, but the implementation of it. We talked with our guests from Sweden. Yes, there are differences in our systems. They have a dual, we have an monistic principle, and we can directly apply the convention. We apply it, and Swedes were surprised. Said, well, no, the situation is different in Sweden. We have Discrimination Act. But I think if people have access to justice and an accessible system of justice, in ideal situation, nobody wants to spend a lifetime while dealing with court proceedings. So I think it has to be implemented, not to go to court. Yes, it's very important. Yes, Yolanta was talking about that, implementation. And towards the very end, what would your wishes be for us? What steps should be taken? Very simple. I wish you all the success, so everything starts functioning in practice. I agree with Indre. Yes, regulation is important, but I see a regulation only effective in that case if it is actually if it's enforced in practice. And do you think it's the function of your Ministry of Social Security and Labor, or maybe Equal Opportunities Ombudsman, could be NGOs, I don't know, as coordinator, or so I think all those relevant world parties, all the stakeholders should discuss among themselves what is functioning, what should be improved, and so that the best possible practical model could be identified. But I'm a supporter of the processes which have already been initiated. And when we have a uniform system in the country, and the indicators as well as reports, we as coordinator of horizontal principle, we analyze every year the situation on the basis of which pieces of legislative framework we base our recommendations. So in conclusion, I do wish the practical instrument to be elaborated, so it's not on paper, but it's alive and it's functioning, and it works well, because we need this live mechanism of coordinating, and the structure is needed, meaning the body responsible for that.
And as our colleagues from the Ministry of Health and Education said, our fields are very extensive. Even in one single ministry, some coordinating body structure or person would be necessary. And I also heard some said the law on strategic governance should foresee it, and it should be mandatory, not optional. Sometimes we see people try to circumvent it, but it's my practical wishes on the topic. Asta, what would you see as important steps? Now it seems everybody is responsible for everything. Everybody makes efforts. It's like a boat, and you see the boatmen very just straining, but no progress is made. Our just rowmen should work hand in hand, and a higher speed should be achieved. So more authority should be granted to the body supervising equal treatment. All proposals should be applied, but they should not be of recommendatory in nature. The weight of decisions made should be higher. In case it's not possible to implement, recommendations based on goodwill should be enforced. And on the other hand, as mentioned already, each institution should be socially responsible. Top leaders should not tolerate intolerance. So that's my wish. Thank you, Asta. Just pass the mic to Jurga. what you can say in order to sum up. What could be helpful in your field to be more effective? I'd like to support Indre's thoughts. Some guidelines and education would be helpful, in particular for employers who are willing to step in and lacking knowledge. So best examples, tips would be important. The coordinator would also be good, yet I'm not the expert to explore the topic. And as mentioned at the beginning, the practical application and practice around a specific individual and workplace, we need consultants or assistants, whatever they are called. And I see greater involvement by NGOs. Thank you. It's a very important aspect. People with disabilities should be involved in all and any decisions. Before leaving, what would you wish to those who are taking over your work? What should be done for all the early steps to be successful? We didn't touch one more important element. It's resources and allocation of resources. It's a key to problems. If we see unwillingness to allocate resources, things get stuck. And such decisions are made by managers. It influences the way particular fields get regulated. So we need managers who can lead in the process from the beginning to the end. I was listening to the examples from the employment field, and it seems as if leaders and managers are key in this sphere. Yes, I'm referring to all managers, starting from the bottom level and up to the top. We should be systematic, and we need many answers to be given. Yet solutions come to resources very often. So all organizations, also NGOs starting from the new days of activities of the new government, they should be active, highlighting how important the matters we focus on are. So I'd like to wish to keep the fire in the topic, not allow anybody to come down. So your summary is for the very end. I was listening to everybody. I felt much consensus. And I know in the field of health care, the literacy of residents and patients is very helpful. The second line of direction, looking from the political perspective, is to monitor the implementation of decisions taken. Or you should celebrate if you are successful, or improve if you failed. How to reach our consumers, our patients, not only disabled but also injured, must be able to access health care institutions. Understanding, education, resources, as well as investments in the sector of health are necessary, be it new investments or existing ones. Universal design as well as reasonable accommodations are highly important in the sector. Now, going back to people who are here and who follow us remotely, I'd like to join in the pre-seasonal wishes. I'd like to note three topics, three B's. The first, or C's. The first is communication, both interpersonal and personal. Cooperation is about solutions we look for, and today's event is also about a dialogue, and community is the third C. It was highlighted in today's forum. So please take away the feeling of communication, cooperation, and community. Make proposals to the ministry how to remove barriers. Thank you, Odeta. And to finalize, I'd like to say thanks for the whole day you allocated to us. It's very important. And we know regulation is very important. We need guidelines to help in all fields. Supervision and mentoring, education. Everybody should start from a personal example. In addition, all the stakeholders should sit together and be passionate in order to implement the guidelines. The Lithuanian Disability Forum and the Commission will update you on the news. I hope the process will continue meaningfully and our achievements will be meaningful. Asta Marčiulionytė, Ignas Gaižiūnas, Jurgita Kuprytė, Jolanta Sakalauskienė, Indrė Širvinskaitė, and Jurgita Vitkūnienė, and me, Odeta, were here together with you. Thanks for our audience and see you in the next meetings and other important discussions.